back in session. Please be seated and come to order.
All right, today's date is February 21st, 2025. This is a combined preliminary hearing and bond hearing in the matter of State versus Charlton Liner, 25 CR 297. Two allegations, one of first-degree murder and then one of felony murder, alleged offense date of January 27th. Before we get into the proof, are there any motions on either side? Anything we need to take up before we just get right into the hearing?
Judge, I would just note that the state is designating Detective Don Nation as the prosecuting officer and would therefore just ask it be put on the record that he is exempt to the rule of sequestration.
All right. Any response to that?
No, Your Honor, they're calling the rules, I understand. Is that right?
I would think so. Has the rule been requested?
Yes, Judge.
Okay. So the rules requested, Officer Nation as the prosecuting officer can remain in the courtroom. How many witnesses does the state intend to call today?
Judge, the state intends to call 5 witnesses. Or, I'm sorry, 5 witnesses for the preliminary hearing, 1 additional witnesses for the bond hearing. Will we be doing both hearings simultaneously?
Well, I guess, does either side have thoughts on that? Usually we can put on the proof of the preliminary hearing, and I think as long as I don't sign the judgment, if sides want to call additional witnesses for a bond consideration, we can do that before I lose jurisdiction. But either side have an objection to that?
That's what I
Go through the original proof and then put on a bond hearing.
That's what I understood we were doing based on your comments from the last hearing.
All right,
No
so that's
objection,
fine.
Judge, so it'd be a total of 6 for the state.
All right. Anyone who wants to have a seat, just file on in. All right, so anyone who's planning to be a witness today for the state side, and I'll do the defense if there's a defense side for the bond later, but anyone who's planning to be a witness, if you'll just come stand right up in front of me, and we'll swear you in collectively, and then I'll re-emphasize that with each witness.
Your Honor, just so we're clear, because we're doing a joint hearing, the witnesses that the defense plans to call for bond purposes only, are they going to be allowed to stay in for the prelim, or are you going to exclude them from the courtroom?
What's the state's?
The state's position would be that everyone would need to be excluded because it's one hearing with a dual purpose.
So the state's witness on bond will not remain in the courtroom?
No.
Okay, so they'll be leaving. All right, so let's do that. If their witness is leaving for for this whole thing, then your bond witness can leave as well.
I have a couple gentlemen under subpoena, that's the reason I asked.
Okay, so I guess anyone who's going to be called as a witness today will have to leave after they're sworn in. So I guess I'll start with the state witnesses. If anyone who's planning to be a state witness will come, just stand right in this area right here.
Judge, we would need just one moment, so, oh no, Danielle got them. We had already set them up so that they were not present.
John, could you ask them to give their names for the record in case they decide not to call them for strategic purposes?
All right, any objection for them to put their name on the record before they file out?
That's fine, Judge, but we have one more witness coming
All right.
before we begin.
Is that last witness for the bond hearing?
Yes, Judge.
All right, and your witnesses, you don't have any for the preliminary hearing?
Correct.
I'll swear in all the bonds people after that, so we can just get right
Yes,
into
Judge.
it, okay? So these are all the witnesses for the preliminary hearing. That's fine.
Yeah.
If they're here, we'll bring them in.
Would you like my witnesses up as well, Your Honor?
If they're in the courtroom, they can come up at this time.
Call them. I subpoenaed these gentlemen, Your Honor.
All right. And we'll just go, after that, we'll go right through the line of your name, I'll put on the record, but it's easy to do it just one all together so we don't forget as we get through the proof. Everyone raise your right hand for me. I have 1, 2, 3, 4, 5, 6, 7, 8 people in front of me raising their right hand. Do each of you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Yes. All right, and we're going to start from my left to the right. Just put your name on the record, please.
Tammy Watkins.
Jay Collins.
Ralph Petty, Cody Fox, Don Nation,
Jason Whittemore, Brian Collins.
All right, they have all been sworn in as witnesses today, and the rule has been invoked, so Don Nation can remain in the courtroom throughout this proceeding, but everyone else will only be able to be in when they're testifying or at the end of their testimony. So the state can call their first witness at this time.
Judge, that would be Tammy Watkins.
All right, so everyone else except Don Nation will have to leave. Ms. Watkins can come up here. And if you want, you can sit down. Our microphone's actually made more for standing if you don't have a problem with that. All right, the door is closed. You may begin.
Thank you, Judge. Can you state your name one time for the record?
Tammy Watkins,
And Ms. Watkins, where do you work?
Bradley County 911.
And what is your position at Bradley County 911?
I am the records clerk.
And what does that entail? What are your duties as a records clerk?
I make copies of the CAD where we take the calls. I make the audio of the calls that are recorded.
Okay. And you said that you make copies of the CAD associated with a call. Can you explain what is a CAD? What does that refer to?
It's a computer aid dispatch record. When someone calls in on 911, the dispatcher will take the call and type in what they say into the CAD.
Okay. Would that report also include information about the date, the time, the duration of the call?
Yes.
Okay. Would it include the phone number and any address given associated with the call?
Yes.
Okay. And is that report made at or near the time that the call is actually occurring?
Yes.
Okay. And you described recording the calls themselves.
Yes.
Is that an audio recording?
Yes.
Okay. And are those audio recordings made at the time of the call?
Yes.
And the employees that work at Bradley County 911, anyone who's handling calls, do they have a duty to make these reports and these recordings?
Yes.
Okay. Judge, could I approach?
You may.
Ms. Watkins, do you recognize these two items?
Yes.
What is this first item, this paper document?
That is the CAD report. That is all the information that was taken on the call when it was called into 911.
And you said the call. What specific call are you referring to?
It's a gunshot call that came in at 135 Arthur Lane.
Okay. And this second item, do you recognize this?
Yes, that's the audio that goes with this CAD report.
Okay. And did you review the audio on this disc specifically?
Yes.
Okay. And is the CAD report associated with the call and the audio on this disc, are those both fair and accurate representations of the information collected by the dispatcher who took the call and fair and accurate representation of the call itself?
Yes.
Okay. Judge, at this time, the state would move to introduce these items into evidence as a collective exhibit, 1A being the CAD report and 1B being the 911 call.
All right. Any objection?
Not for the purpose of this hearing, Your Honor.
All right. So I will receive those.
And Judge, the state does intend to play the 911 recording through a later witness, but I do have a few questions for Ms. Watkins just about 1A. Ms. Watkins, looking at 1A, on that CAD report, Can you locate where it identifies the phone number that made the call?
Yes, it's right here.
And what is that phone number?
It is 423-715-2614.
And what is the date and time of that call?
127:25 at 08:44 and 16 seconds.
Okay. And is that time in military time?
Yes.
Okay. What would that time be in just standard time?
8 o'clock and 44 minutes and 16 seconds a.m.
Okay. And what is the incident location on Exhibit 1A?
135 Arthur Lane Northwest.
Okay. Judge, those are all the questions that I have for Ms. Watkins.
All right, any questions?
No, Your Honor.
All right, thank you, ma'am. You can step down.
Thank you.
Judge, the state's next witness would be Ralph Petty.
All right, sir, just stand right at that microphone, and obviously you're still under oath to tell the truth.
Yes, sir.
All right. Anytime you're ready, General.
Thank you, Judge. Sir, could you state your name for the record?
Ralph Petty.
Mr. Petty, where do you live?
I live at 146 Arthur Lane, Northwest in Cleveland.
And is that a residential neighborhood?
It is.
Does the neighborhood have a name?
Kings Court.
Okay. How long, if you know, if you have any knowledge, has that neighborhood existed?
We've been there about 2.5 months now, and a friend of mine developed it. I guess it's been 6 months, 7 months old.
Okay, so it's
Yeah.
fair to say it's a relatively new subdivision?
Yes, ma'am.
Okay, and is that here in Bradley County?
It is.
Okay. Do you know Karen Liner?
I had met her about back before Christmas for HOA functions when the neighborhood was getting established.
Okay.
And prior to that, no.
Did she live in your neighborhood?
She did.
Okay.
Mhm.
Approximately how far does she live from your house?
It's it's about, I would say, around 80 to 100 yards,
Okay.
just guessing.
And is she like a next door neighbor, either on the right or the left, or across the street?
Across the street and down toward the entrance.
Okay. And at your home on 146 Arthur Lane, do you have any security cameras?
I do.
How many do you have, and where are they located at your
I
house?
have 2, and again, we just moved in, so there was 2 installed. And there's one in the front and one at the back.
Okay. And the front camera, what does that cover in that camera range? What
Well,
is it pointing at?
it basically is at one corner of the eave, and it covers, it can go pretty much all the way to the entrance to the neighborhood, pretty close, but it covers a pretty wide span.
Okay.
And the
So-
driveway itself, obviously.
Okay, thank you.
Mhm.
So that front camera, the area that it covers, is Karen Liner's residence within that area of coverage?
It is, yes, ma'am.
Okay. And are those cameras that start recording, they're activated by motion, or is it a camera that is always recording?
It's always recording.
Okay, and do you know if, when it does record, if that video has sound, or is it just visual?
It does both. It has sound and visual.
Okay. On January 27th of this year, were you contacted by police regarding your security video?
Yes, ma'am.
And did police request any of your security video?
They did.
Okay, and did you comply with that request?
Absolutely.
Okay. And the video that you provided to police, was it a fair and accurate representation of what your camera covered at the time that they requested the video from?
Yes, ma'am.
Okay. And, Judge, if I could approach the witness?
You may.
If you'll give me just one moment, Mr. Petty, I have to show the things first. Show the difference compared to the first just waiting on a response from the defense.
Your Honor, I'm not lodging an objection for the purpose of this hearing, but I would like to approach and be able to watch and see with my own
Yes,
eyes.
that's fine.
And Judge, I would just note, similar to Ms. Watkins, the state intends to authenticate and introduce this item into evidence through this witness, but would play the exhibit should it be admitted through a subsequent witness.
Okay, that's fine. So he's just being used to get it into evidence?
Yes,
this time?
Judge.
Okay, that's fine.
Mr. Perry, I'm going to show you just a couple seconds of this video, and then I will pause it and ask you some questions.
Okay.
Do you recognize this video?
That's no driveway.
Is this the video that was recorded by the front camera that you described having at your home?
Yes, ma'am.
Okay. And is this the same video that you described providing to law enforcement?
That's correct.
Okay.
That's what
Judge,
They came and retrieved that, and that's what it was, yes.
thank you very much. Judge, at this time, the state would move to introduce this item into evidence as Exhibit 2.
All right, any objection to me receiving that into evidence?
Not for the purpose of this hearing.
Okay, so that'll be received as Exhibit 2.
Judge, those are all the questions that the state has for this witness.
All right, now the defense will get a chance to ask you some questions if they want.
Okay.
Sir, at the time that this video was allegedly captured by your security system, were you home?
Yes, sir.
Okay, did you see personally any of these events take place, or did you just go back and review the video?
I did not see them. I just was alerted to that by the police.
Okay, thank you.
Thank you.
Anything else?
The state has no redirect, Judge.
All right, thanks for your step down.
Thank you, sir.
Thank you.
Judge, the state's next witness would be Cody Fox.
All right, and obviously, Detective, you're still under oath to tell the truth.
Yes, sir.
Can you state your name for the record?
Cody Fox.
And what is your occupation?
I am a lieutenant with the Cleveland Police Department.
And how long have you worked in law enforcement?
14 years.
Has that all been at the Cleveland Police Department?
Yes, ma'am.
Okay. And were you working in that capacity on January 27th, 2025?
Yes, ma'am.
On that date, did you respond to a shooting?
I did.
Where was that shooting?
It was on Arthur Lane.
And what was your involvement in that investigation?
Well, I did a few different things. I responded to the scene. Also responded to the Stafford residents along with the Bluff Drive residents. And I took the victim's phone from the scene on Arthur Lane to the police department for forensic processing.
Okay. And you described responding to a location on Stafford. What is the significance of the Stafford location?
That is Mr. Liner's residence.
Okay. And you also described a location that was on, was it Pine Bluff?
I believe it's Bluff Drive or Bluff Road.
Okay.
Yeah.
And what's the significance of that location?
That is Mr. Collins' residence.
Okay. Do you know Mr. Cole's first name?
Jay, I believe.
Okay. And you talked about working with the victim's phone. Is that Karen Liner's phone?
Yes.
Okay. When you were looking at the phone as part of your investigation, did her phone show that there was a 911 call made from that phone on that morning?
Yes.
Okay. And, Judge, if I could show the witness Exhibit 1A, the CAD report?
Yes, I've laid all the exhibits out here and we'll just keep going across.
I'm showing you what has been introduced into evidence as Exhibit 1A. Do you recognize the 2614 phone number listed as callback phone?
Yes, I believe that's Miss Liner's phone.
Okay. And during your investigation, were you able to obtain Ring camera video from cameras associated with Ms. Liner's property and her Ring camera account?
Yes, we were.
How many videos were you able to recover?
We were able to get into the entire account, but specific to the incident in that morning, we recovered 2 videos.
Okay. And as a individual who has worked in law enforcement for the length of time that you have, do you have any experience or knowledge in that capacity, how Ring cameras work, how they record video?
Yes.
Okay. Is a Ring camera a type of video that is always recording, or does something have to trigger a recording to start?
It depends on the settings. In this case, it was motion that would set it off to start recording.
Okay, so the Ring cameras associated with Karen Liner's account are activated by motion.
Yes.
Do you have any knowledge if the user has the ability to change the level of motion that triggers a video to start?
Yes, I've seen that in my experience.
Okay. In your investigation reviewing the video, are you able to make any determinations on if that Ring camera was set to record? Did it have a high sensitivity for motion triggering or low sensitivity?
That's not something I noted.
Okay, but we have 2 videos. That was your testimony?
Correct.
Okay. And Judge, if I could approach the witness.
You may.
Give me one moment. I'm going to speak to the defense first. I am going to play the first couple seconds of each video for you and then ask you some questions.
Okay.
And then while I get that pulled up, did those 2 videos that you recovered, did they have audio?
I don't recall.
Okay.
I don't recall if either one of them had audio or not.
So this would be the first video of the 2, and I'll just play the first few seconds. Do you recognize this video?
I do.
And what is it?
It is a video from the Ring camera that's facing Miss Liner's driveway from that morning at about 8:45.
Okay. And are there timestamps on the video itself that help you to determine the time?
Yes.
Okay. And is this first video a fair and accurate representation of the, I'll call it a coverage area of that camera?
Yes.
Okay. I'm going to show you a few seconds of the second video and ask you some additional questions. Do you recognize this video?
I do.
What is this?
This is a video of the same Ring camera facing Miss Liner's driveway with officers approaching the scene at 8:48 or 8:49.
Okay. Is it accurate based on your testimony regarding the timestamps that this video takes place after the first video that you just watched?
Yes, ma'am.
And is this second video a fair and accurate representation of that camera's coverage during the timestamp indicated on the video?
Yes, ma'am.
Judge, at this time, the state would move to introduce this disc containing 2 videos as Exhibit 3, and we intend to publish these videos through a subsequent witness as well.
All right. Is there any objection?
No, Your Honor.
All right. They'll be received as Exhibit 3.
I'd like to talk to you a little bit more about your involvement with the Stafford location, and you described that as the defendant's residence, is that correct?
Yes, ma'am.
And why did you go to that location?
Attempting to locate Mr. Liner.
Were you able to locate Mr. Liner?
We did, yes, ma'am.
Describe that for us.
I called him on his cell phone. We were able to track down his cell phone number and told him that we needed him to step out of his residence and in a way that where we could see that his hands were free of any weapons, and he agreed and did so, and he was detained at that point.
Okay. During this phone conversation where you were speaking with Mr. Liner, how did he sound? Was there anything about your conversation with him that indicated his demeanor at that time?
He didn't ask any questions. He complied with our request. Outside, I would say that he was unemotional. No questions. No questions as to why we'd asked him to step out of the house.
And was he calm when you interacted with him once he exited the house?
Yes.
Okay. And while you were at that location, did you observe any vehicles that were at the residence?
Yes, inside the garage.
Do you recall the make and model of the vehicle?
I believe it was some type of Range Rover or Land Rover, golden color. I'm not sure on the make or model, but I believe that was the style.
Okay. Judge, those are all the questions that I have for this witness.
All right.
Detective Fox, if I may, these locations that you talked about, you first went to Arthur Lane, is that what I understand?
Yes, sir.
And then the next place you went, can you tell us?
The next place I went would have been Stafford.
Stafford, and is that in a named subdivision like Arthur Lane is?
Bentley Park.
It's in Bentley Park, and I asked that, does Bentley Park have any security, gates,
They
fences,
do.
that sort of
They
thing?
have a gate, yes.
Okay. Tell me about that. Is it an automatic gate, or do you have to have a code?
It's not. We actually had to get on the radio and attempt to get a code from someone who was either back at the scene or any officers that had knowledge or dispatch had knowledge of it. And someone gave us the code to get in, but I'm not sure how they communicated that.
I saw that in your report. So when you left Arthur Lane, you went over to Bentley Park to go to the alleged defendant's residence. You had trouble getting in. How long were you out there trying to figure out how to get in the gated community?
A minute, 2 minutes or so. I'm not really sure. It was longer than a minute.
I noticed that in your report, that you had some trouble out there.
Yep.
So it's not a situation where you decided it was important to break down the gate or go around the gate or travel through the...
We would have had a tough time getting through the gate, yeah.
Okay. All right. Is it a gate with a fence that circumferences the whole subdivision, or could you simply just walk around it and go through the woods?
You may be able to, I'm not sure.
Okay. You wanted in there because you knew that to be the residence of the victim of this, is that correct?
Mr. Liner.
Yes, right. It was Mr. Liner's residence, correct?
Correct.
Did you know whether the victim and Mr. Liner still co-owned the residence or not?
Not at that time. I didn't have that knowledge.
How did you know it was Mr. Liner's residence?
We were communicated that through other officers that were looking into any information that they could find, and that was a previous address for Miss Liner, and I believe they were able to look it up and figure out that it was the current residence of Mr. Liner.
So just through public record databases and things like that's how you
Yes, sir.
came to that conclusion,
Yes, sir.
correct? It wasn't because you or anybody knew that's where Mr. Liner lived because there had been prior incidences at the residence or anything like that?
Not to my knowledge, no, sir.
Okay. Once you got in the subdivision, is that when you called Mr. Liner, or did you call him from the outside of the gate?
Once we were inside, yeah, we had, the driveway is really steep, so we stopped at the base of the driveway and actually went about 100 yards past that and stopped, got out and discussed some of our options, and I was communicated the cell phone number of Mr. Liner, and that's when I called him and asked him to step out of the residence.
Do you know what time it was you called Mr. Liner?
I don't
Do
recall.
you know how much time had passed, even if it's approximate, from the time you received the 911 call that's in evidence through the CAD report to the time you called Mr. Liner?
I don't recall.
Would you say it was 30 minutes or more, or over an hour?
I would say it would be 30 minutes or more. That's
30 minutes or more.
all I could be certain of.
Based on your investigation thus far, do you know whether Mr. Liner left the Arthur Lane residence and went straight to his home, or did he make another stop and go somewhere else?
I don't have that knowledge, no.
You don't know?
No, sir.
Okay. Was he reliable in answering his phone?
Yes.
Did he answer the first time?
Yes, sir.
Okay, and he didn't give you any problems?
No, sir.
He followed your commands?
Yes, sir.
Came out, like you said, with his hands up, I guess? Is
Yes,
that what
sir.
you instructed him to do?
Yes, sir.
All right. He did not resist arrest?
No, sir.
How far did he come out of his residence to meet you? Did he have to come down that big, long driveway, or did you meet him?
So the driveway kind of winds up the hill, and there's landscaping. He walked down the landscaping, so it's probably 50 yards from the front door of the residence.
Did it appear to you that Mr. Liner was attempting to flee?
No.
He went home to his known address, is that correct?
Yes, sir.
All right, and he provided his person to you at your demand and request?
Yes, sir.
Did he have ample time to leave?
From the scene? Yes, sir.
He did?
Yes, sir.
Those are my questions, thank you.
Anything else?
Just briefly, Judge. You testified just now that the defendant, during your phone call and interactions in person with him, was compliant. He did not resist. Is that accurate?
Yes, sir. Or
Okay.
yes, ma'am.
Would you say that that behavior is consistent with someone who is not in a distraught emotional state?
Yes, I would not describe him as distraught.
Okay, because he understood and complied with all of your request commands. Was that your testimony?
Yes.
Okay. I have no further questions for this witness, Judge.
Anything else?
Yes, Your Honor. General Zepeda asked you, Detective, if he was emotional, and you didn't you affirm that? You said besides emotion, he was compliant?
I said he was unemotional. Yes, sir.
Okay. Back to the subdivisions. Bentley Park and this Arthur Lane address, how far away are they from one another?
Ooh. Less than a mile, half a mile.
Are they essentially off of the same main road?
They are off of, I don't know what the road off of Northley Highway is, but it's off the same road off of Northley Highway.
And when you turn on that road, it appears initially that you're going into one subdivision called King's Den, is that correct?
Correct.
All right, and so when you go into King's Den, the Arthur Lane property is to your right, Bentley Park is on down past that a ways, is that correct?
I'm not sure about the Arthur Lane. I don't remember. I know Bentley Park is in King's Den.
Sure. And so would it be fair to say that the defendant in this case was found essentially within the same community or subdivision as where the alleged incident took place?
Yes, sir.
Thank you.
No additional questions from the state, Judge.
All right, thank you, sir. You can step down.
Judge, the state's next witness would be Dawn Nation.
All right.
And Judge, if I may have permission to collect some of the exhibits already entered into evidence?
Yes. She's doing that. Sir, obviously you're still under oath to tell the truth.
Yes, sir.
Can you state your name for the record?
Dawn Nation.
And what is your occupation?
I'm a detective with the city of Cleveland.
How long have you been a detective?
I've been a detective on and off in different fields for almost 7 years. Did 6 years as a narcotics detective. Then I went back to the road and ran a shift for a year, and now I've been back since 2023 as a people crimes detective.
And how long have you worked in law enforcement in total as a detective or in other roles?
I began my law enforcement career in 2008, and I believe it was in March. Roughly 16 years, almost 17.
Okay. And Detective Nation, were you working on January 27th, 2025?
Yes, sir, I was.
And did you respond to a shooting on that date?
Yes, ma'am, I did.
What was the location of that shooting?
It was 135 Arthur Lane.
And what was the first thing that you did in the investigation?
I was called by my lieutenant to respond, and I responded to the Cleveland Police Department and spoke with Mr. Liner.
What was Mr. Liner's appearance and demeanor at the time that you spoke with him?
He was unemotional. He appeared as a normal person would appear. Nothing of note other than he asked no questions about why he was there.
Okay. You stated that he asked no questions about why he was there. At any point, had you informed him why he was there?
Yes, ma'am, I have.
Okay. And so it's your testimony that subsequent to that, he had no questions for you?
No questions. No, ma'am.
Okay. And following that interview with Mr. Liner, what was the next thing that you did in the investigation?
I began to assist another detective, Detective Kilby, in writing various search warrants. While writing those search warrants, I also reviewed some of the video that had came in from the Vivient ring camera at 146 Arthur, and I also reviewed the 911 recordings that came in from the Bradley County 911 Center. During that process, I was notified by Lieutenant Ratcliffe that a vehicle matching the description of one of the vehicles in the video was located on Bluff Drive. He sent me a photo of that video, and I was able to confirm that those vehicles were similar in make and model to the one that was on the Vivient camera.
Okay. I'd like to go back to those videos that you just described. And Judge, if I may have permission to approach the witness?
Yes.
Mr. Rogers,
Yes.
if you wanted to be closer to observe, Detective Nation, do you recognize this?
Yes, ma'am, I do.
Okay. What is it?
That is the video from 146 Arthur Lane. It is zoomed in onto the driveway of 135 Arthur Lane, which is the residence of Karen Liner.
Okay. And is this zoomed in portion of the video fairly and accurately depict just that specific area of the overall video?
Yes, ma'am, it does.
Okay. And Judge, for the record, I will be playing from the 1 minute and 39-second mark. You'll give me just one moment to turn on the audio. Oh, Judge, I apologize. You need to see as well. Do you have a preference on how I position this?
Put it there, pointed that way, we can all.
Okay.
Do you like me to step up?
Yeah, if you want to come over and we can.
Well, I'll step over there.
Right.
I'll get right here. I had intended to fix the televisions this week, and we've run late in court most nights, so.
And Detective Nation, before I play it, when I have additional questions for you, I'll let you know so that we can get you back in front of the microphone.
Okay.
So this is Exhibit 2, starting at 139. At August, Judge. Detective Nation, I have stopped Exhibit 2 at the 2 minute and 2 second mark. The vehicle that has just entered the screen from the left, is that the same vehicle that you just described as a suspect vehicle that you located on a Bluff address?
Yes, it's the same color. Appeared to be the same make and model.
Okay, and I'll resume that. For the record, I am pausing at the 3-minute and 31-second mark. Detective Nation, where is Karen Liner at this point in the video?
She is laying with her head facing the road on her back, and her feet is facing the garage. She is on the driveway where the walkway comes in, very close to the garage itself.
I'm going to object to that conclusion as speculation. It's clear from the video that maybe the detective has more information than we have, but from what he's saying he's seen, you obviously can't see that.
Yeah, I think the
Detective.
question was a little bit confusing
I can lay more
because we're talking about a
foundation,
video,
Judge.
but it's not seen in the video.
Are you relying on knowledge that you have obtained through sources other than the video regarding your testimony just now that she was laying on her back and what direction she was facing?
Yes, ma'am, I am.
And what are those other sources of knowledge?
Crime scene photos, other videos which will be introduced. That is my basis of knowledge.
Okay. I will-
So this time I'm going to overrule the objection because it's more of a foundation was laid. It's not seen in the video, so I sustain that portion.
Judge, I will be resuming from that 3-minute and 31-second mark. For the record, I will be stopping the video at the 4-minute and 37-second mark. Detective Nation, if you would like to position yourself back in front of the microphone. That last portion of the video that we just watched, can you tell us what did the individual in the video do after Miss Liner's body falls to the driveway?
From the video, it appeared that he stepped back into the garage for a few seconds. It looked like, from what I could see, he had bent down, unsure what he was doing at that moment. He then walks back out of the garage and appears to sit in the driver's seat of the white sedan that was in the driveway. The vehicle is started. After a few seconds, he then appears to step out of the vehicle and shoot at least one more time.
Okay. And the position that a few minutes ago you described Karen Liner's body, the position that it was in on the driveway, to your knowledge and your involvement in the investigation, is that the position that her body was found in when law enforcement responded?
Yes.
Okay. For the record, I will be playing Exhibit 1B, the 911 call recording. Mr. Rogers, I was going to put it in the same position if you wanted to be closer to hear the audio.
Yeah, can I have just a moment? We're discussing something.
That's fine.
Thank you for the pause, Your Honor.
Get out of my driveway.
911,
135 Archer Lane. Please stop. Please stop.
135. Can you hear me, ma'am? You said 135 Archer Lane Southwest. Ma'am, are you okay? Ma'am, can you hear me? Ma'am, can you hear me? Who's shooting? You still there, ma'am? I heard multiple shots. It sounded like shots. She's not responding. Are you still there, ma'am? You still there, ma'am? Can you hear me? Can you still hear me, ma'am?
For the record, I am stopping at the 1 minute and 34-second mark. Detective Nation, what was that last sound that can be heard on the recording just a few seconds before I paused it?
It sounded like a gunshot.
Okay. And did this recording from the 911 call and the video that you just watched that has been introduced into evidence as Exhibit 2, did those items help your investigation?
Yes, they did.
In what way did they help the investigation?
It gave us, one, a time frame of how long the assault itself had taken place. It provided us with, in the 911 tapes, a name that was given.
I'm going to stop you for 1 second. I apologize for interrupting you, Detective Nation. But what was the name that was given?
Craig.
Okay. And do you know the defendant's full legal name, first, middle, and last?
I believe it's Charlton Craig Liner.
Okay. And do you have any knowledge of whether the defendant went by Charlton, Craig, or another name entirely?
From the people that I've spoke to in the course of my investigation, they all referred to him as Craig.
Okay. And going back to what you were discussing, so you were answering my question on how that video and that 911 recording aided your investigation. How did it aid the investigation in any other ways aside from that name, Craig, and the description of the vehicle and length of the scene as you've described?
Another thing that was of note from the video for our investigation is that as soon as he arrived on scene, she was yelling at him and screaming. From the video, it appeared that the garage door was shutting and he had went under the garage to gain access to the garage.
Okay. During your investigation, were you able to determine whether that home at 135 Arthur Lane, was that owned solely by Karen Liner? Was it owned jointly by Karen Liner and the defendant?
It was solely owned by Karen Liner.
Okay. Detective Nation, how many shots can be heard on the audio of both the 911 call and the video recording in Exhibit 2?
From the audio, you hear what sounded like 4 shots from the audio on Arthur. Maybe 5, I think it was 5. From the audio on the 911, the first shot can be heard at 8 seconds into the audio, or what sounds like a shot. It's not as loud, and then a series of, then there's 1 shot, then a series of 2 shots, and then 1 more shot, and then several seconds later there is a 5th shot, I believe.
Okay. And Detective Nation, to your knowledge, based on your investigation, how many times was Karen Liner actually physically shot?
3 times.
Okay. And Judge, if I could play what has been introduced into evidence as Exhibit 3 for the witness. Would you like to approach?
Is it just audio?
This one is no audio, just video.
This is a Ring camera. That's Exhibit 3.
Yes, Judge, the 2 ring camera videos on Exhibit 3. And Detective Nation, if you want to step around just so that you have a better view of the video. I am showing you the first video on Exhibit 3. For the record, this video begins with a timestamp of 8:45:05 Eastern Standard Time. Playing from the beginning. Okay. Detective Nation, in that clip that we just observed, were you able to better identify the suspect that exited that vehicle?
Yes, I was.
And Detective Nation, if you want to go back in front of the microphone, I'm going to ask you a few questions before I play the second video. With that better view, were you able to identify the individual in the video?
Yes, I was.
And who did you identify that individual as?
Charlton Liner.
Is he in the courtroom today?
Yes, ma'am, he is.
Could you point him out for the record?
He's sitting with blondish gray hair, orange jumpsuit, and a white undershirt.
He has been identified.
Thank you, Judge. Detective Nation, in the video that we just watched, and I'm going to, while it is paused, go to a specific point in time, actually just from the beginning, so the 0000 mark, and if you want to come around to take a look, in this still shot of the video, and I'm going to wait to ask my question until Mr. Rogers can view where the video is at. At this point in the video, can you see any part of Karen Liner's body?
Yes, I can.
Just using your finger, can you point out on the screen and describe the area where you can see a portion of her body?
So on the screen, there's a small shrubbery just on the end of the vehicle. On the ground, you can see a portion of what appears to be a white tennis shoe.
Okay. And Detective Nation, this video is time-stamped from the Ring camera, and at this specific point in time, what does it show the defendant doing?
Walking to the driver's side of the car,
Okay.
and looking down.
Based on this video and the timestamp and date on the video, were you able to determine when during the shooting that occurred, those multiple shots, this portion of the video is from? Was it before shots, in between some of the shots, after all shots had been fired?
This portion is after the last, not the very last shot, but the last shot heard that were very close together, but before the final shot.
Okay, so is it accurate, is it your testimony that this video takes place between the second to last shot and the final shot?
Yes.
Okay, and is that the same portion of the incident where, when watching Exhibit 2, you described the defendant entering his vehicle and turning on his vehicle?
Yes.
Okay. And then I will show you the second video that is on Exhibit 3. Okay, so starting from the beginning, and it is approximately 30 seconds long. Yes, I am going to put it on a paused portion. Okay. Detective Nation, just starting at the beginning, while the video is paused at the 0000 mark, can you describe where Karen Liner's body is?
Yes, she is at the top of the driveway. If you're facing away from the garage, she is on the right side of the driveway. Her body is right next to a walkway that will take you to the front door, and it appears that her head is in the grass and she is laying on her back.
And could you, approaching the video as it is paused at that point, point out the shoe or foot that you described as being visible in the first video on the same exhibit?
It's the left shoe. And you can see from the previous video, you can see the toe portion of that shoe.
And is this the driveway located at Ms. Liner's residence, at 135 Arthur?
Yes, it is.
And is that here in Bradley County?
Yes, ma'am, it is.
Okay. So after reviewing video, at any point in your investigation, did you go to a residence on Bluff Drive?
Yes, while reviewing video and assisting with writing search warrants, I was notified by Lieutenant Ratcliffe that a possible vehicle was located on Bluff Drive at the residence of Jay Collins.
And what was the relevance of that vehicle?
It was believed to be the same vehicle that is seen in the Ring camera and in the Viviet camera.
And what is the make, model, color, just general description of that vehicle?
It's a light colored Lincoln MKZ.
Okay. And did you ultimately locate that Lincoln vehicle at the Bluff Drive residence?
Yes, I did.
And do you have any knowledge of who owns that residence?
It's Jay Collins.
Okay. And do you have any knowledge of any relationship between Jay Collins and the defendant?
I learned through speaking with Jay Collins that they were cousins.
Okay. And where on that property of Jay Collins was the Lincoln located?
So as you pull it onto Bluff Drive, he is the house at the very top of the cul-de-sac. His driveway, or his house, has two driveways. There's an upper driveway, which is on the left side if you're facing the house. And then there is a second driveway on the right side of the house that is a lower driveway. That vehicle was at the end of the lower driveway facing a wood line and a pond, parked. It looked as if there was an area designed for parking out of the way of the garage, and that is where the vehicle was located, next to a trailer.
Was the vehicle still running, or was it turned off?
It was turned off.
And were there any individuals present inside the vehicle?
No, there was not.
Okay. Were you able to determine who that Lincoln vehicle belonged to?
Yes, I was.
And who does it belong to?
So it did belong to Charlton Liner. I don't remember if Karen was also listed on that vehicle registration as well. I believe it was registered to both.
Okay. Would you have more information on the registry of the vehicle in your case files and some document or notes?
Yes.
Okay. And did you locate any additional evidence from the vehicle?
Yes, I did.
What evidence was retrieved from the vehicle?
We located a spent shell casing. The stamp on the back of the shell casing showed that it was a .40 caliber. We also located, and without looking at my notes, I can't tell you the exact number of, looked like blood stains. They were red in color, similar to how a blood stain would look. On the hood of the vehicle, near the driver's side, also located a small red that appeared to me to be a blood stain on the driver's side door near the bottom of the vehicle.
Okay. And in your experience in law enforcement and your knowledge from your participation in this investigation, is the occurrence of those blood stains that you just described on that part of the Lincoln consistent with the way that Ms. Liner's body fell, as we saw that in Exhibit 2?
Yes, that would be the same side of the vehicle that she had fallen near.
Okay. And speaking just generally to the property itself, Jay Collins' residence, not just the Lincoln, anywhere from Jay Collins' residence on Bluff Drive, did you recover any firearms?
Yes, I did.
How many firearms did you recover?
A total of 3 that day.
And were you able to determine who those firearms belonged to?
Yes.
Who did they belong to?
Charlton Liner.
Okay. And were any of those firearms that were recovered that belonged to Charlton Liner, were any .40 caliber, the same caliber as that bullet casing that you just described?
Yes, we located a Glock .40 caliber semi-automatic pistol. It was on a wheel, underneath a wheel well of a trailer that was parked next to the Lincoln.
Okay. Did you locate those firearms? And actually, I'll first preface my question with this. I am not asking you to give me a statement verbatim from another person, but without getting into a content of a statement, did you locate those firearms? Did law enforcement find those firearms on their own, or did they find them in response to information that they were given about their location?
We were directed to their location.
Okay. And were there any other vehicles that you saw at the Bluff Drive residence?
When I arrived, Jay Collins' vehicle, I don't remember or recall what type of vehicle that was parked in the cul-de-sac, not in the driveway, but there was no other vehicles that I saw at that residence.
Okay. And just going back briefly to the defendant's arrest, are you aware of the location that the defendant was arrested at?
Yes, I know where he was detained.
And where was that?
The Stafford residence, I don't recall the exact numerics.
Okay. And at that Stafford residence, were there any vehicles that were located at that address?
I believe a Land Rover Defender, golden color, was in the garage there.
And do you have knowledge of who that vehicle belongs to?
Yes, it belongs to Charlton Liner.
Okay. And do you have any knowledge of how the defendant got to his residence on Stafford from Bluff Drive where Jay Collins lives?
He drove his Land Rover.
Okay. And to clarify, what was the vehicle that the defendant was in when he arrived at Miss Liner's residence?
The Lincoln MKZ.
Okay. In Detective Nation, was there an autopsy done on Karen Liner's body?
Yes, there was.
Judge, if I could approach.
Yes.
Judge, the state would seek to introduce the autopsy final report as a report made by an expert witness under the Tennessee Rules of Criminal Procedure 5.1.
Any objection?
No, Your Honor.
All right. We received as Exhibit 4.
Thank you, Judge. Detective Nation, I'm showing you what has been introduced into evidence as Exhibit 4. Do you recognize that document?
Yes, I do. It's the autopsy report that I received from the regional forensic in Knox County.
Okay. And Detective, can you read what is listed under narrative on that first front page?
Yes. This 51-year-old white female, Karen Liner, died of multiple gunshot wounds. The manner of death is homicide.
Okay, thank you. If I could have just one moment, Judge.
That's fine.
Judge, the state has no further questions, and that would be the final witness for the purpose of establishing probable cause at the preliminary hearing.
All right, Mr. Rogers.
Sure, I do have some cross. Mr. Nation, thank you for being here today.
Judge, I apologize, and I'm so sorry to interrupt,
It's okay.
Mr. Rogers. We do have one final witness for the preliminary hearing, but that would conclude the state's direct of Detective Nation. I
Okay,
apologize
I
for the
understand.
miscommunication.
Understood. Mr. Nation, you've been designated as lead law enforcement on this case. How does that happen?
So I'm in a unit of 3 people crime detectives. We were on a rotation as far as the homicide rotation, and I was up. And I was notified by my lieutenant that I was to come out.
So it's just a matter of rank, convenience, scheduling, that sort of thing?
It's a fair way of giving out large cases.
You were assigned to this case. How did you know it was a large case from the beginning?
Any case that involves a person's death is what I consider a large case.
Okay, all right. So it's not within the realm of all homicides. Any homicide you would consider a large case?
Yes.
Okay. Your first order of business when you were told by, I think, your lieutenant, is that correct, that you'd be assigned to this case, was to go to the police department to interview the defendant. Is that correct?
That's correct.
All right. At what point in time did you actually go to the scene, or have you been to the scene?
I have, yes.
Okay, did you go that same day?
Yes, yes, sir.
It's okay. How late in the day?
It would have been several hours later.
Okay. Because your initial attention was turned to Mr. Liner?
My role when I first got there was to interview Mr. Liner.
And as I understand your testimony from just a few moments ago, you said that Mr. Liner had little to no affect. He didn't seem emotional.
He did not.
Is that typical? when you have somebody that's been involved in something so serious, some large case involving a homicide?
Everyone reacts differently to extreme emotion, so.
Okay, all right. It seems like you did a lot of research. You looked at car records, home records, phone records, all sorts of things in this case. Did you look up to see whether or not Mr. Liner had a criminal history or a criminal record?
I haven't ran his criminal history yet.
So as you stand here before this court today, you don't have any knowledge about whether or not he has criminal history?
I do not.
Okay. You went to the police department first. Where was Mr. Liner when you arrived there?
He was in the interview room.
Okay. Y'all have a room that's designated for suspect interviews?
For all interviews.
I assume that you would agree that he was in custody at that time. He'd been taken there in handcuffs?
He was detained.
He was detained, all right. And I assume you Mirandized him. You read him his rights before you began the interview process?
I got his initial information and gave death notification, and then immediately read rights.
Tell me about the death notification.
What
do you mean by that?
I asked him if he knew why he was here. He advised no, and I then informed him that his ex-wife had been found dead at the residence at 135 Arthur.
Okay. And then you read him his Miranda rights?
Yes.
Okay. And I'm sure, I've been doing business with you for a long time, I'm sure you recorded that, probably through audio or video recording?
It was recorded, and it's also documented by signature.
Okay, so you have a paper writing about that?
Yes.
And did Mr. Liner sign that, waiving his rights to speak with you?
He did.
Okay. And how long did that interview last?
Not very long at all.
Okay. Where did Mr. Liner get sent after that?
He stayed there.
He stayed there at the police department?
Yes.
Eventually he was transferred over here to the county jail, is that correct?
Eventually, yes.
Did you do like you see sometimes, take the defendant out to a scene or go gather information or anything, or did he go directly from the police department to the jail?
He went straight from the interview room into the Bradley County Jail.
Okay. And he's been there ever since, is that correct?
That's true.
And that's, he's been there since January 27th?
Yes.
You said earlier in your direct examination that it appeared that Mr. Liner bent down and you couldn't tell if he was picking something up or not.
From that video and my other investigation, I don't know why he was bending down.
So as you stand here today, after you've had time to reflect and investigate, you don't know what he was bending down for?
No.
Did you receive any information from any outside sources about this matter or who they think the suspect might be?
I did not.
Okay. And by the time you got involved, the suspect had already been arrested, is that correct?
He was just detained. He was not necessarily the suspect at that moment.
Detained or arrested, he wasn't free to go, right?
He wasn't free to go.
Okay. Did you make the report for the affidavit for the warrant in this case?
Yes, I did.
You're the one who drafted that?
Yes.
All right, did you put in that report that you received calls from an employer of Mr. Liner's?
I'd have to see the report to refresh my memory.
You don't remember whether the hospital that he worked for called?
I know they have, but I don't recall whether I put it into the affidavit or not.
Fair enough. Did you read your affidavit in preparation of today's hearing, or has it been a while?
I've read it in preparation. However, there's a lot of information in there.
You said a moment ago that you found spent shell casings. You're talking about in the vehicle at Mr. Liner's residence or someone else's residence?
The shell casing was on the vehicle at Jay Collins' residence.
Jay Collins' residence.
Yes.
On the vehicle, where would it have been, where was it?
It was on the passenger side windshield wiper.
Okay. Did you conclude that it had traveled with the vehicle from Arthur Lane to Mr. Collins' residence?
I concluded at that moment that it was a spent .40 shell casing.
Okay. Did you find any others, or just the one?
At Bluff Drive or on Arthur?
Well, let's go with Bluff Drive.
No others.
Okay. You said you found 3 firearms there?
Yes.
That day?
That day, yes.
Did you find others some other day?
I was notified by Jay Collins of an additional 45-1911 that was in the leaves next to his garage.
Okay. So the shell casing you found was a 40, and then you found a 45 later on?
Later on, yes.
Okay. That same day or different day?
It was a different day.
All right. That same week?
Yes.
Did you find shell casings back at the Arthur Lane residence?
Yes, I did.
How many?
I believe we found 4.
4? Were they of the same caliber?
They were 40 caliber, yes.
They were 40 caliber. Did any of those get sent off for ballistics testing by TBI or any other laboratory?
They're all being sent.
Okay, and what about the firearms?
It's all being sent.
All the firearms or just the 40 and the 45?
I'd have to look at my notes. We're sending quite a bit of evidence.
Understood. I assume this is an ongoing investigation, is that correct?
It is.
All right. Was Mr. Liner GSR tested?
Yes, he was.
Okay. Anybody else?
The deceased was also tested.
You said that Mr. Liner was the owner of the guns. I understand and acknowledge how you can figure out who the registered owner or the titled owner of a vehicle or a residence or property is. Would you agree with me that guns aren't necessarily registered?
Yes.
All right. There may be an initial purchase registration when it's purchased new, but guns can change hands. There's a lot of debate about that. Would you agree with that?
Yes.
There's no way to tell who a current owner is of the firearm. Would you agree?
No.
During your investigation, have you gone and looked at civil records or litigation between the victim and the defendant as far as divorce or lawsuits or anything of that nature?
We have their divorce records, yes.
You do. Just one moment, please, Your Honor.
Yes.
Did you have any problem with Mr. Liner cooperating with your command since he was detained?
Are you asking if he was cooperating with everything I asked him to do?
Yeah, as far as like where to go, where to sit, where to show up, or follow your commands?
Yes, he was cooperating.
Those are my questions, Your Honor.
Just a few on redirect, Judge. Detective Nation, you testified on cross with the defense that you did not go to the actual scene of the shooting until later that day. Is that typical for a detective who is working on a homicide to not initially respond to the scene?
It's typical. We have a team of detectives that work these. Sometimes a detective will respond straight to the scene. Sometimes other detectives and crime scene techs are processing the scene. In this case, there were several different scenes.
Okay. Do you have any knowledge of who the initial law enforcement personnel to arrive at the scene of the shooting on Arthur Lane were?
Yeah, it was 2 patrolmen.
Okay. And is that unusual for patrolmen to respond before a detective to a scene like that?
No, it's not.
Okay. And you also testified on cross about what the defendant could have been doing when he bent over in what has been introduced into evidence as Exhibit 2, the Vivint security video from across the street. Is it accurate that your testimony on cross was that you cannot say conclusively what he was doing. We don't have any evidence that shows exactly what he was bending over to pick up or do. Is that accurate?
Yes, from the video, it's too blurry to tell exactly what he was doing.
Based on your investigation, your observations of evidence, and just other involvement in the investigation in general, do you have an idea or opinion on what he could have been doing?
Yes.
Okay. And what is that opinion?
My opinion is that he was picking up a pair of glasses that had fallen.
Okay. And what is that based on?
Evidence of glasses being on the ground that was located on the scene during the search warrant.
Okay. And when you say glasses, are you referring to the frames and the lenses, or a specific part of the lenswear?
I'm referring to the lenses in general as the evidence located on the scene. I'm referring to picking up the glasses as an entirety as what, my opinion, is what he was doing.
Okay. And did you observe the defendant at any point in possession of a broken pair of glasses?
I observed the defendant with a pair of glasses that were missing a lens, yes.
And did you recover a single lens from the crime scene at the location of the shooting?
Yes, there was one recovered.
Okay. And you also testified on cross about the interview that you had with the defendant. Did the defendant ever make an admission to you?
No.
Did the defendant ever express any remorse to you?
No.
Okay. The defense also asked you on cross about the defendant's employment at a hospital. Do you have any knowledge of the defendant's employment status on January 27th?
I know that he was let go from his job, yes.
Okay. And final question, Detective Nation. You were asked about an additional gun that was recovered from Jay Collins' property. Was that gun the same caliber as the casing that was found on the Lincoln?
No.
Do you have any reason at this point in your investigation, with the evidence that you've collected thus far, the people that you've spoken to thus far, do you have any reason to believe that that gun was involved or was used to shoot Karen Liner?
No.
Okay. And just briefly, so you described that there has been evidence that's been sent to TBI for testing, is that correct?
Yes, there has.
Would that testing include things like DNA testing, looking for fingerprints, gunshot residue analysis like the defense brought up?
Yes.
Okay, and so those are things that we are waiting for the results on, is that correct?
That's correct.
Okay, one moment, Judge. Judge, I don't have any further questions.
All right. Do you have anything else?
No, Your
All
Honor.
right, thank you, sir. You can step down.
And Judge, the state's next witness and final witness for the purposes of the preliminary hearing probable cause determination would be Jay Collins.
Right, and obviously, sir, you're still under oath to tell the truth.
Yes, sir.
Thank you, Judge. Can you state your name for the record?
Jay Collins,
Mr. Collins, where do you live?
3245 Bluff Drive,
And is that here in Bradley County?
Cleveland.
Okay. And Mr. Collins, do you know the defendant, Charlton Liner?
Yes, ma'am.
How do you know him?
He's my first cousin.
Okay. And do you see him in the courtroom today?
Yes, ma'am.
Could you point him out for the record? Okay. And Mr. Collins, we record our hearings, but it is just an audio recording, so if you don't mind, could you verbally describe him, maybe like the color of his clothing or where he's positioned?
Gentleman sitting over here with brownish gray hair.
Okay, thank you, Mr.
Right,
Collins.
he has been identified, defendant.
Mr. Collins, I'd like to take you back to what you were doing on January 27th, 2025. On that date, did you see the defendant?
Yes, ma'am.
And then, just briefly, so before you saw the defendant on January 27th, when was the last time that you had seen the defendant?
He was over at the house watching a football game Sunday night.
Okay, and would that be the Sunday night before Monday, January 27th?
Yes, ma'am.
So the night before?
Yes, ma'am.
Okay. And the night before, when he was over watching a football game, what was his behavior like, his demeanor?
Normal.
Okay,
He just seemed like Craig. I mean,
okay. So there was nothing about his appearance or behavior that stood out to you as not normal. Is
No,
that
ma'am.
accurate?
yeah.
Okay, thank you, Mr. Collins. Leading up to January 27th, did the defendant have any vehicles that he left at your residence on Bluff Drive?
Yes, ma'am.
What vehicle was that?
There was Lincoln.
And why was the Lincoln left at your house?
Well, he bought it for his son, was my understanding, when he wrecked his car. And he drove it over there one night. We had a couple of beers watching the ball game. He got an Uber home. He got an
Okay,
Uber home, left the car there.
okay. And when you say he, are you referring to Mr. Liner
Yes,
brought the
ma'am.
car over and Ubered
Yes,
home?
ma'am.
Okay. Do you know, so was that Mr. Liner's primary vehicle that he typically drove day to day?
No, that was an extra car.
Okay. Do you know what his primary vehicle was that he would typically drive?
A Range Rover Defender.
Okay. And did that vehicle, the Lincoln that he left there, you said he bought it for his son. Was it in the son's name or was it in Mr. Liner's name? If you know.
I have no idea.
Okay, if you don't know, you don't know. Mr. Collins, I'd like you now to walk us through the morning of January 27, 2025. What was the first thing that you did that day when you woke up?
Got up and went to work.
Okay. Do you recall approximately what time you went to work?
6:30, 6:45.
Okay. So would it be fair to say somewhere between 6 and 7 a.m. approximately? Okay. And did you stay at work after that, or did you come back to your residence?
Well, I
at
went
some
back
point?
by the house to drop something off.
Okay, and approximately how long after you had left for work was that you came back?
I went back, it was around 9, I guess.
Okay. And so when you left for work between 6 and 7 a.m., do you recall if the Lincoln was still parked in the driveway?
As far as I know, I got so used to seeing it, I didn't pay no attention. Cause I parked in the upstairs and the car was downstairs.
Okay, so that, would it be accurate to say that the Lincoln was essentially a fixture of your driveway, something that you're used to being there?
Yeah.
Okay. Let me ask you this, Mr. Collins. When you came back around 9 a.m., do you recall if the Lincoln was still there?
No.
Okay. And were there any other vehicles present that were not your vehicle when you came back around 9
The
a.m.?
Defender was there.
And what vehicle was the defendant in?
What do you mean?
Was he in a vehicle? Was he driving?
Oh, he was gonna sell that Lincoln.
Mm-hmm.
So when I pulled in, dropped off what I had to drop off, was leaving, I saw the Defender and thought, well, he's come to get it to sell it.
Okay.
Then he pulled in, and I said, what are you doing?
Okay. And so when he pulled in, did he pull in driving the Lincoln or driving the Range Rover, Land Rover that you described as his primary
Lincoln.
vehicle? Driving the Lincoln? Okay. Was his other vehicle at your house?
Yes.
Where was it? Was it parked somewhere in the driveway?
Yeah, I got a little pull off, but it was parked down there.
Okay.
Yeah.
Is it unusual for the defendant to leave that primary vehicle, the Land Rover, at your house?
Yes and no.
Okay.
Cause he's left it before, but not a whole lot, you know what I mean?
Okay. So it is not as permanent a fixture as the Lincoln was. Is that accurate to
No.
say? Okay. And when you saw the defendant pull into your driveway around 9 in the Lincoln. What happened next?
I got out and said, what are you doing? He said, I said, what's going on? He said, nothing. I said, what are you doing? I thought you had to work. Well, I need to get rid of this.
And when he said, I need to get rid of this, what was this? Did you know what he was referring to that he needed to get rid of?
Well, it ended up being a couple of guns.
Okay,
That he had talked about storing guns at my house.
okay. I'm gonna ask you 2 follow-up questions about that. So first, you said a couple of guns. A couple can mean different things to different people. Approximately how many guns did he have when he said, I need to get rid of this?
2 or 3.
Okay. And then you testified that he had said something to you before about storing guns at your house. Was that your testimony?
Yeah.
And tell us more about that. When was that?
Couple of weeks, I guess, because they were selling their house. He was moving into an apartment. They didn't want the guns in the apartment.
Okay. So is it
So I was
fair-
gonna let him put them at the house.
Okay. So is it, actually, let me ask you this. Where were those guns going to be stored at your house? Did you two ever discuss a specific location in your house that they were going to go? Okay.
No, I just figured I'd go in there and put them in the closet.
Okay. And so he made that statement to you that he had to get rid of these. What happened after that statement? What was the next thing that occurred?
He put them in the house.
Okay. Did you continue to speak with the defendant as
Yep.
you entered the home?
And he said, well, it's over. I said, what are you doing? It's over. I said, what do you mean? I finished it, or I was in a state of shock at that point. And I was like, what?
Okay, Mr. Pond, so is it your testimony that he said something to the effect of, it's over, and something to the effect of, I finished it?
Something like that.
Okay. Did you ever ask him what he was referring to, what he finished, or what was over?
Yep, and he said, like I said, it's over. Or I was like, huh?
Do you recall if at any point the defendant told you that he had taken care of my problem or taken care of a problem?
That's the way I took it.
Okay. And what did you take the problem to be? What was the problem that he took care of? What was finished?
Well, I figured it was his ex-wife.
And why did you figure it was his ex-wife?
I just figured that, took
Okay.
it that way.
And do you know who his ex-wife was?
Yeah, Karen.
Okay. Is that Karen Lina?
Yeah.
Okay. Thank you, Mr. Collins. Did you ask the defendant at any point what gun he used to take care of his problem? Or something to that effect?
Something to that effect.
And did he answer you?
Yes, ma'am.
What was his answer?
The 40.
Okay. And when he said the 40, what does that mean to you? Is that referring to a brand of firearm, a caliber of firearm?
Caliber of gun.
Okay, so you took that to mean he used a 40 caliber to take care of his problem. Okay, thank you, Mr. Collins. And finally, so during this time that you are speaking with the defendant, once he got out of the car, as you move into the house, what was his appearance and behavior at that time?
Kind of like normal. He didn't act like he'd done anything.
Okay.
So I was trying to figure, is it true or not true? Because I hadn't heard anything.
Okay.
So I told him, I said, you gotta be kidding. I said, go home. And I went to go back to work, and I started calling people, see if I could find out what was going on.
Did you speak to law enforcement at any point?
That's who I was trying to call.
Okay. Did law enforcement ever come to your residence on Bluff Drive?
They did a few minutes later.
Okay. And what did you do? So you described telling the defendant to leave. Did the defendant leave your home?
Yes, ma'am.
Do you know what vehicle he left in?
The defender.
Okay. So is it your testimony that when you got home from work around 9 a.m. that you saw the defendant arrive at your house in the Lincoln while the Defender was in your driveway, but he left your home in the Defender.
Yeah,
And did the Lincoln remain at your home after he left?
yes, ma'am.
Okay. Did you cooperate with law enforcement when they arrived at your home?
Yes, ma'am.
And did you provide the firearms that the defendant had given to you to law enforcement?
Yes, ma'am.
Okay. And what did you do with the firearms after the defendant left?
Well, I left two of them inside, and I went in, put a rubber glove on, and moved the 40
Okay.
outside because I didn't want it in the house.
Okay. And why did you specifically not want the .40 caliber gun in the house?
Because that's what I thought he said he used.
Okay. And were you truthful whenever you spoke to law enforcement on January 27th when they came to your home?
Yes, ma'am.
And were you truthful today in your testimony?
Yes, ma'am.
Okay. One moment, Judge. Okay. And just to clarify, Mr. Collins, so you described getting a glove to move the .40 because you did not want it in your home. Where did you put it when you took it out of your home?
I took it outside and put it on the tire of my trailer.
Okay. And was it in that same location when law enforcement arrived?
Yes, ma'am.
Okay. And did that firearm go from that location on the tire of the trailer to law enforcement?
Yes, ma'am.
Okay. One moment, Judge. Just briefly, Mr. Collins, so you said there were 2 to 3 firearms in total that the defendant had. Was that your testimony?
Yes.
Okay, and you've described one as a .40 caliber. Do you recall what the other guns looked like? Anything about their appearance? Whether they were pistols or rifles?
One was a pistol, one was a shotgun.
Okay. And when you said he had those with him, did you observe him take those take those firearms out of the vehicle, the Lincoln that he drove up in?
I don't really remember, I just assume he did.
Okay. Were those firearms at your house prior to January 27th?
No, ma'am.
Okay. Judge, I have no further questions.
Mr. Rogers?
Mr. Collins, thank you for being here. I'm Matthew Rogers. We spoke on the phone the other day. Is that
Yes, sir.
correct? You said that defendant Liner was at your home the evening of January 26th. Is that correct?
Yes, he was. I don't, whatever the date was. Whatever the date the ball game was.
Okay, so Sunday
Yeah.
before this incident.
If you say it's the 26th, 27th, yeah.
Was it the night before?
Yeah.
Okay. How was defendant acting?
Normal, fine. He didn't act weird or nothing.
Okay.
It's kind of like normal.
So he wasn't more quiet than usual or more loud than usual. Is that
No,
correct?
yeah.
Your first cousins, have you had a close relationship your whole life?
Oh, yeah, I've known him my whole life.
Okay, all right. Have you lived in the Cleveland area your whole life?
Yes, sir.
Okay. You said that you had a couple beers or beverages the night before watching the ball game. Did Mr. Liner, as far as you can remember?
Yeah, he had 3 or 4.
Okay. Did he drink to excess? Did he?
No, that's me.
Oh, that's you. Okay. All right. As far as you can recall, you've been cousins and known him for a long time. Is he the type of person that would drink to excess?
No.
Go overboard?
No.
All right. Would he be responsible?
Oh, yeah.
All right. You said a moment ago that he would take an Uber home if he had a
Yeah.
couple beers or maybe more. I don't
Well,
know.
yeah, you'd normally drink 2 or 3, 3 or 4 and go home.
Okay.
If he had a 6-pack, he'd normally take an Uber home.
Okay.
Leave a vehicle there.
All right. But that particular night, he seemed fine when he left?
Oh,
Your
yeah.
residence? Okay. Had he been making plans with you or anybody else to move or do anything like that?
Yeah, he was selling the house. He said had the movers coming Friday.
Okay.
And then a buddy of mine was gonna help him move some stuff.
Okay. That Friday, that following Friday?
as far as I know.
Okay, was he talking about plans to move that following Friday?
Yeah,
All right, and recruiting help to do so?
yeah.
All right.
He didn't tell me that. He knows I'm gonna help move shit.
Okay.
Right. No cussing in court.
Sorry,
Understand?
sorry.
You had a mutual friend that he was talking to about helping him move some things, is that
Yeah.
correct? All right. Did he let you know anything else about any of his other plans, besides maybe the guns? He wanted to leave them at your,
No, he just said I've got an apartment and we gotta get everything out.
okay. You've lived here all your life, is that correct, Mr. Collins?
Yes, sir.
You said you got up that morning and went to work. Where do you work?
Collins Oil Company.
Okay. And is that a family-owned business, I
Yes,
assume?
sir.
All right. And has that been your employment your whole adult life?
Yes, sir.
Okay, how old are you?
61.
61. You never moved away, you always been here?
Always been here.
All right. What about Craig Liner, your cousin? Has he been here?
Yes, sir. Well, he went to school and come back and has always been here, around here in Chattanooga, yeah.
Okay. What type of work has he always been involved in?
Pharmacist.
Pharmacist for more than 10 years?
Oh, yeah,
More than 20 years?
yeah.
Okay. As long as you've known him, in his adult life, he's been a pharmacist?
Well, yeah, ever since he graduated college.
Okay. Where'd he go to college, do you know?
Auburn.
Auburn, okay. So he left to go to college, came back, he's been part of the community the rest of his life.
Yes, sir.
All right. So as far as his employment status and history, you know that to be a pharmacist in this area?
Yes, sir.
Okay. What about financial condition? Has he had hard financial times, or has he always been stable? As far
He's
as,
always been stable, as far as I know.
okay. You're obviously family. Does he have other family ties and relationships here in Bradley or surrounding counties?
Well, me, my brother, and my aunt is probably the only family he's got.
Okay. Do y'all have family in other states, or is that where the only family he has is?
I reckon we're the only family he's got.
Okay. All right. And do you all live here in Bradley County?
Yes, sir.
Do you know anything about Craig Liner's mental condition? Has he ever had mental problems or anything? Or has he been stable?
He's always been stable.
Okay. In your opinion, does he have a reputation for truthfulness?
Yeah.
Okay. Do you know if he's ever missed any court proceedings that he was supposed to be at?
I don't reckon he's ever had any.
Okay. All right. Do you know whether or not he's ever had a record of flight to avoid prosecution?
No, Craig's good as gold.
Okay. Do you know whether or not he has, well, I'll skip that. You said he's good as gold. The question I have for you for the purpose of bond, sir, is Mr. Liner reliable?
Yes.
If he tells you he's going to be somewhere, will he be there?
Yeah.
Does he have a history of standing you up?
No.
If he says he's going to do something, will he do
He
it?
says I'll be over about 5:30, 5:15, 5:30, he'll show up.
Okay. Is he a responsible person in your opinion?
Yes, sir. Very much so.
As far as you know, he's lawfully present in the state of Tennessee, is that correct?
Lawfully what?
Present. He's a
Yeah.
United
Oh,
States
yeah.
citizen. Right? Those are my questions. Thank you.
Anything else?
Yes, Judge, just briefly. Mr. Collins, so you testified that the defendant was a pharmacist just now on cross. Had the defendant told you that he had been fired from that job as a pharmacist?
No, ma'am.
Okay. Did you have any knowledge of his status of employment on January 27th?
No, ma'am.
Okay, after the fact, have you acquired any knowledge as to his job status?
Somebody said he got fired, but he didn't tell me because I thought he left to go home and was gonna get up and go to work Monday morning.
Okay, so it is your testimony that the defendant was losing his house, they were selling the house?
Yes, selling it, yeah.
Okay, and you had knowledge after the fact that he had also lost his job, is that accurate?
Yeah.
Okay. And then You told the defense that you would agree that Mr. Liner has a reputation for truthfulness. Is that correct?
Yes,
And was it also your testimony that if he told you he was going to do something, you believed that?
yes.
Okay. So when the defendant told you that he had taken care of his problem, did you believe him?
Not really.
Okay, so not really. Why would you talk to law enforcement if you didn't believe him?
I just didn't think he could do it.
You didn't think he could do...
I didn't think he had the killer.
Okay. Did you believe him when he said that he used the 40 to do it, to take care of his problem?
I didn't know.
Okay.
That's the reason I was trying to call people to see if something was going on.
Okay. Would it be accurate to say that you suspected it could be true because you took that one specific firearm out of your house?
Yep, I guess.
And were you scared when he said that it was the 40? Why did you take it out of the house?
Well, because if he did it, I didn't want it in my house.
Okay, so would it be accurate to say that a part of you believed that he could have killed Karen Liner when he made those statements to you?
Yeah, because I didn't know what he was doing at the house.
Okay.
So I was like, well, something's going on. What?
Okay, it was out of the ordinary. Is
Yeah.
that a fair way to put it?
Yeah.
Okay, one moment, Judge. I don't have any further questions for this witness,
You got anything
Judge.
else?
Speaking of ordinary, sir, did you have any reason to believe before January 27th that Mr. Liner was capable of violence?
No.
That he always acted appropriate when it
Yeah.
came to arguments and that sort of thing?
Yeah.
The DA portrayed it as Mr. Liner was losing his house. Is that what you understood it to be? Or
No. They got a divorce and they was having to sell it.
They were selling his house? Okay, and that was by agreement?
Yeah.
I assume you're fairly close with Mr. Liner. Did you talk with him as he was going through that divorce process
Some.
about whether to make agreements or not or anything like that?
Well, was pretty private about all
Judge,
that.
I'm going to object because if this is going to elicit statements from the defendant, that would not be admissible as a hearsay exception of a party opponent. The defendant or the defense cannot get in self-serving hearsay.
I didn't ask him what Mr. Liner said to him. I asked the witness whether he'd conversed with Mr. Liner or not. My next question was going to be, did you try to talk Mr. Liner out of agreeing to the terms?
All right, I'm going to overrule the objection. I think there is some motive at play here that was elicited the last go-around from the state, so I'll allow a little bit more on this path we're on.
Jay Collins, did you try to talk Mr. Liner out of agreeing to the terms that he did
No.
about selling his house?
I just said, do the best you can and go on. Then the divorce was final, and I said, let it go. There's water under the bridge.
And then y'all didn't have much conversation about it after that?
Like I said, he didn't talk to me a whole lot about his finances and all that. He was kind of personal with all that.
Okay. Those are my questions. Thank you, sir.
I have no further questions,
All right,
Judge.
next, sir, you can step down.
The state's last witness for the purposes of the proof for the bond hearing would be Margaret Hopper.
Let's just put all the proof in, and then we can argue everything at the end. So we can keep going. You can call your next witness if you'd like. Well, do you have any witnesses for the preliminary hearing? No. You can call your witness for the bond purpose.
Thank you, Judge. That would be Margaret Hopper.
Well, she's coming in. We've been going almost about 2 hours. I think it'd probably be best to take about a 5 to 10 minute break. So let's go ahead and break and come back right at 12:15. We will get through this before breaking for the day. So at 12:15, we'll go till it ends.
All rise. This court is now back in session. Please be seated and come to order.
All right, the record is back on. Let's move on with the witnesses for the bond portion of this hearing today. The state can call its next witness.
That would be Margaret Hopper, Your Honor.
Cam, if you'll just stand right at that microphone. It has been a while since we've seen each other today. You are still under oath to tell the truth.
Yes, sir.
Can you state your name for the record?
Margaret Hopper.
And what is your relationship to Karen Liner?
I'm her mother.
Okay. And Mrs. Hopper, as you stand here today, do you have concerns for your safety or the safety of anyone else should the defendant be released from jail?
Absolutely.
Okay. And could you explain why you have those concerns?
Yes, I have something written. Can I read it?
If
I'm going to object to that. The bond factors are fairly limited. It's not whether someone in particular has specific articulable concerns. It's whether the defendant's prior criminal record and likelihood that because of that record, the defendant will pose a risk of danger to the community.
Judge, the state's response would be that that is not accurate, just looking at the plain language of 4011-118. With the recent change by the legislature, quite specifically, the court is to determine what is necessary to reasonably ensure the safety of the community. And the state would submit that Mrs. Hopper is absolutely a member of the community.
All right, I do think that the recent changes to the bond statute puts a very high priority on public safety, and I am going to allow this witness to express why she does what she wants to express on this matter.
Ms. Hopper, let me hold on to that, and if at any point you cannot recall what you want to say, and looking at that might help refresh your recollection, what I can do is let you look at it for a moment, take it back, and then ask you the question again. Okay. And I'll re-ask that last question, Mrs. Hopper. So can you explain to the judge why you have those concerns?
First of all, my family and I are horrified that there's even a possibility of bond for Mr. Liner after the actions that he took on January 27th. His 14-year-old daughter is in my care now, and I am very afraid for her and for my grandson that if their father was in the community, they would not be able to even function, nor would I, nor would my husband, nor would my son, nor would my daughter-in-law, nor would my other granddaughter. We would all be terrified of the fact that he was in the community that we live in. The only solace that we have at this moment is that he is behind bars. And that gives us some form of safety and being able to sleep a little. I feel that if I took my granddaughter to a practice, an activity, I'd be afraid to let her out of my sight if he was free to walk in the community.
Mrs. Hopper, you testified that your granddaughter is living with you, is that correct?
That's correct.
Okay, and this granddaughter would be the defendant's biological daughter?
That's correct.
Do you have legal custody of that child?
Yes, we do.
Okay. Judge, I have no further questions for this witness.
No questions, Your Honor.
All right, thank you, ma'am.
Thank you.
Sorry for your
Ms.
loss.
Hopper, I'll return that to you, and you are free to stay in here, or if you want to leave it, I'll take you. Judge, that would conclude the state's proof at this time.
All right, I think defense had some witnesses for bond.
Jason Whitmore. Whitmore, Jason.
Right to that microphone, sir. It has been over 2 hours since we saw each other last. You are still under oath to tell the truth.
Yes, sir.
Sir, please state your name and spell your last name.
Jason Whittemore, Whittemore.
Okay. Mr. Whitmore, I subpoenaed you to be here today, is that correct?
Yes, you did.
Okay, we spoke on the phone in the last week or so about the situation, is that correct?
Yes.
Can you tell the court what you do for a living currently?
I'm a farrier
Okay. How long have you been doing that?
since 1998.
Since 1998. Before you were a farrier, sometime in the middle of that, did you have another profession?
Yes, I did.
And what was your job other than a farrier?
I was in law enforcement.
Okay, and in which department?
Well, from 1990 till about 2008, I worked for several different departments.
Okay. Was one of the departments here in Bradley County?
It was.
Okay, was it the Cleveland City Police Department or the Sheriff's Department?
Cleveland City from 1990 to 93.
Okay,
And 93 from about 98 was Chattanooga City.
okay,
And then here in Bradley County and then with the state.
okay. And what was your job with the state?
ABC.
Okay, so you have a long history of work in the community and in the law enforcement community, is that correct?
Yes.
Is it true, sir, that you personally have been assigned to investigate homicide cases here in Bradley County?
Yes.
Okay, approximately how many?
3.
3? Were you lead on those cases?
I was not lead, but I was an investigator in those cases.
An investigator in the cases? So you're familiar with the courtroom setting, you've testified before?
Yes.
Okay, here in this very courtroom?
Yes.
Okay, as a witness for the state?
Yes.
All right. Do you know Charlton Craig Liner?
I do.
Okay. How long have you known Mr. Liner?
Personally for probably about a year.
Okay. During that year, did you come to realize that he was going through a divorce or a separation from his wife?
At one point in time, yes.
Okay. Have you, during the last year or so, have you developed a personal relationship with Mr. Liner?
Yes, we were hanging out frequently, became friends.
Okay. Have you vacationed together?
Yes.
Okay. Do you know personally how long Mr. Liner's been in the community?
I do not.
Okay. Do you know anything about his employment status or history?
He was a pharmacist at Memorial Hospital.
Okay. Do you know, and you may not, how long he'd been a pharmacist?
I do not.
Okay. Do you know if he has other family ties and relationships in the community here?
I do not.
Okay. Do you know the Collins?
Yes.
Okay. Do you know whether or not Mr. Liner's related to them?
I do. They were cousins, I found out.
Okay. Have you developed an opinion about Mr. Liner as to his reliability?
From the time that I've known him, yes.
Okay. What is that opinion about his reliability?
He became a good friend. Takes me a minute to accept somebody as a friend or gain somebody's trust or whatever, and we were hanging out quite a bit. And to me, myself, what I know of Craig and me hanging out with him is a good buddy.
Okay. You said it takes you a minute to accept someone into your friend group. Is that because of your prior experiences?
I guess you would say just from law enforcement, we have a way of just kind of checking people out before you really want to hang out with them.
Okay. In the time that you've known Mr. Liner, been on trips with him, that sort of thing, has he shown up when he's supposed to?
Yes.
Okay. Has he ever stood you up for a meeting or a get-together?
No.
All right. If he has to cancel or has a need to change plans, does he let you know?
Yes.
Okay. You said you traveled together out of state?
Yes.
Did he fulfill his obligations for that?
Yes.
Would you agree that you saw him at least weekly over the last year or so?
Yes.
Right. Anything, you being a farrier in the horse business, a former detective, anything in any of those meetings give you any reason to believe that Mr. Liner was planning on doing anything illegal?
Not whatsoever.
Okay. Did you, in fact, prior to January 27th of this year, have plans to assist Mr. Liner with anything?
Yes, he was going to move into an apartment, and I laughed. I said, well, I don't move furniture. And he had that lined up, but smaller things. He said, if you don't mind one day, if you have some extra time. I said, I don't mind. I said, if you need some help moving some small things, I'll help you do that.
And this was prior to January 27th?
Yes.
Were you with him, in fact, on January 26th, the day before?
If that was Sunday before, yes.
Sunday before, yes?
Yes.
Okay, and where were you with him at?
At Jay Collins' house,
Jay Collins' house? What were y'all doing?
watching ball games.
Watching ball games? Is that when you planned with Mr. Liner to help him move the small things from his
I
move?
think we spoke about it then,
Okay.
and maybe a day or two before that also.
Okay,
Just he was having time to get it lined up to get the apartment or something.
okay. And so, as far as you know, he was planning on moving?
Yes,
right? Later that week?
yes.
Do you know specifically which day you and Mr. Liner have planned on getting together to help finish his move?
I think he told me as soon as we get the apartment lined up, it was possibly going to be that Friday.
That coming Friday? After the incident in question that we're
Yes.
here about? Did he give you any reason at the time to think that that he was overly distraught or anything like that, or did he
No.
seem normal?
Seemed normal.
Did he ask you to do anything suspicious? You were a detective.
No,
Didn't ask you to move a car or move a gun or anything like that?
nope,
Didn't ask you to set some money aside for him or anything of that nature?
no.
Okay. If he were to be given bond today, do you have an opinion about whether or not he would show up to court?
To my knowledge, to me,
Yes.
in my opinion, he's a man of his word.
Okay. Are you comfortable being around him if he were released back into the community?
I have no problem with him. That's between him and God.
Okay. All right. Would you still associate with him where
Yes.
he released? I'm sorry.
Yes,
Being a former detective, did you look into his background to see if he had any prior record?
no.
Those are my questions, Your Honor. I pass the witness. Thank you, sir.
Just a few, Judge. So it was your testimony that for approximately a year that you've been friends with the defendant, is that accurate?
Approximately a year.
Okay. Would you refer to the defendant by his first name Charlton or his middle name Craig?
Craig,
Okay. And in the time that you were friends, did he typically go by Craig? Did anyone refer to the defendant as Charlton that you know of?
no.
Okay.
I didn't hear that name.
Okay, thank you. And then, in that time that you were friends, vacationed, did the defendant ever tell you that he was fired from his position as a pharmacist?
No, he did not.
Okay. And did he ever talk to you about his divorce from Karen Liner?
No.
Okay.
I don't ask questions, people's personal business. If they want to talk about it, it's up to them to bring it up. And he never discussed it, and I was not aware of it.
Yes, sir.
Or anything personal.
Okay, thank you. You talked a little bit about the defendant's appearance, behavior the night before when you were hanging out, the night before January 27th, to be clear. At any point in your friendship with the defendant, did you ever have any concerns that he could have mental health issues or anything like that?
No, not whatsoever.
Okay.
And I, think, was there any red flags? Any indication, anything that I could have picked up on, even with experience past? I picked up on nothing.
Okay. And then I would like to talk just a little bit more about your experience in law enforcement. So as a former member of law enforcement, if a murder suspect were to say that he had taken care of his problem with a .40 caliber gun, would you consider that strong evidence of guilt?
I consider that hearsay because he just told me that. I have to see the scene, the victim, and the evidence.
Okay. Let me ask it to you this way in hypothetical. If a defendant made that statement and there is proof that he made that statement, is that statement strong evidence of guilt?
How do I know of the proof?
I'm telling you that there's proof of it in this hypothetical situation.
Hypothetically, I would still have to investigate. I
Okay.
wouldn't make a decision, and that would be up to myself, other investigators, and the state.
Okay. You testified that you consider the defendant to be a man of his word, something along
Yes.
those lines.
Yes.
Okay. So if the defendant made a statement that he had taken care of his problem with a .40 caliber gun, would you believe him, given that he is a man of his word?
Well, that's different. Hypothetically speaking, you're speaking of a crime of somebody that I say that I trusted told me. I would still have to investigate it. I wouldn't take that straight out as yeah, it happened until I knew for certain.
Okay.
Like I said, I would have to see the scene, the victim, some type of something to prove it. Just somebody saying something that strong, you know, you don't know if it's true or not.
Okay. And in the time that you were in law enforcement, do people facing punishment for serious crimes always run?
Not always, no.
Okay.
That's usually high-profile cases like O.J. Simpson or something.
Fair enough.
I mean, no, not that I know of, not cases that we've worked around here.
Okay. And Judge, if I could have just one moment. Sir, are you aware that the murder of Karen Liner was captured on video?
I'd heard that.
Okay. In general, if a crime is captured on video, would you consider that strong proof?
If it was a case I was working, if the video is consistent with the act of the crime, yes, that would
Okay.
be evidence.
In an investigation, would you prefer to have video of the crime taking place?
Yes, because sometimes that's just unspeak. You don't have to speak, you just see it.
Okay, understood. Judge, I don't have any further questions.
Anything else?
You investigated homicides, correct?
Yes,
All homicides are when someone dies, is that correct?
yes,
Just because a homicide was committed doesn't mean it's premeditated first-degree murder, does it?
does not.
Those are my questions.
That's very briefly, Judge. As an officer, if you had a murder case where it was captured on video, they made a statement indicating they took care of their problem with a .40 caliber gun, you have proof that they own a .40 caliber gun, you found a .40 caliber shell casing on the vehicle that they drove away from the murder from, would you consider that proof of premeditation, that he planned to commit that crime when he went with that gun?
I would show that proof enough for me to make an arrest
Okay.
and do an investigation, but
And I just want to ask a
the
clarifying question.
premeditation, I wouldn't know because a video wouldn't show premeditation.
Okay.
His statement of a finishing something or doing that doesn't do premeditation.
Okay.
That would just have to come out further in interviews and
Okay.
investigation, and probably with psychological test.
If someone drove a different car, so a car that's not their normal car, and they had brought multiple firearms, would you consider that something that could be a sign of premeditation?
No, I'd have to investigate more.
Okay.
Like I said, you'd have to interview the suspect and see what's on their mind to determine premeditation.
Okay.
The hard evidence I can't take as premeditation.
Understood.
It will come through, like I said, psychological evaluations, speaking with him to see if he's going to admit it himself.
Okay.
And that, but hard evidence is hard to premeditation.
Okay. It was your testimony just a second ago that based on that type of evidence, you would arrest someone for the
I
crime
could
of
make an arrest
first-degree murder.
on what you told me that the state would have. I could make an arrest on that, yes.
And were you referring to an arrest for first-degree murder?
I'd have to speak with the district attorney to see actually where we're going with this.
Okay.
And the district attorney would look at our evidence and see what we have, and we would decide which charges capable of what happened.
Okay. But you would feel comfortable making an arrest?
I would with that, yes.
Okay. All right. Thank you. No further questions.
No more. Thank you, sir.
Okay.
Brian Collins is my next witness, Your Honor.
Just right to that microphone, sir. It's been over 2 hours since we've seen each other. You're still under oath to tell the truth.
Yes, sir.
All right.
What's your name, sir?
Brian Collins.
Okay, Mr. Collins, I issued a subpoena for you to be here today, is that correct?
Yes, sir, it is.
All right. And Mr. Collins, do you know Charlton Craig Liner?
Yes, I do.
Okay, are you related to Mr. Liner?
Yes, I am.
Okay, please tell the court the nature of your relationship to Mr. Liner.
We are first cousins. His father and my mother were brother and sister.
I assume because of that relationship, you've known him the majority of each other's lives, is that correct?
Yes.
Are you older than he, or is he older than you?
I'm older than him.
Okay, so you've known him the whole time he's been alive, is that correct?
Yes.
Okay. Have you ever known him, besides going off to college, to live anywhere besides Bradley County, Tennessee?
Not to my knowledge.
Okay. Have you maintained a relationship with Craig Liner, the defendant, throughout his life?
Yes, I have.
Okay. Would you agree, like most relationships or family relationships, sometimes it would be more frequent than others?
Yes.
Okay. Did you have a relationship with Karen Liner?
I knew her from being married to Craig and family functions and those types of things.
Sure. So you had a relationship with the whole family?
Yes.
Okay. His children?
Yes.
All right. Do you know whether or not Mr. Liner has other members of family in this community?
Yes, he has other members.
Okay. Do you know of any family that lives outside of this community?
It would be distant relatives.
As long as you've known Mr. Liner, which is his entire life, what can you tell this court about his employment status?
He has always been employed, as far as I know. You know, after he got out of college and got his pharmacy license, he's been a pharmacist for a long time.
More than 2 decades?
Yes, more than 2 decades.
Maybe 3 decades?
Maybe more than 3 decades, yes.
Okay. All right. Have you known anything about his financial condition?
Limited, yes, but limited.
Okay. Would you say that his financial condition was stable, or had he had problems?
Stable, no, he's very stable financial condition.
Okay. Do you have a good relationship with Mr. Liner?
Yes.
All right. Do you have family ties with Mr. Liner?
Yes.
All right. Are you able to opine about his character, his reputation?
Yes.
All right. Would you say his character and reputation is good or poor?
Good.
All right. Has he been honest with you through the years?
Yes.
Has he been dependable?
Yes.
Has he been reliable?
Yes.
If Mr. Liner were to make a mistake or owe someone something, have you seen him take or make efforts to make that right?
Yes.
All right. Do you know whether Mr. Liner has a prior criminal record or not?
Not to my knowledge.
All right. Do you know whether there's a record of Mr. Liner's ability to appear at court proceedings?
I think he would have a good record of being able to appear wherever he was supposed to be, or at court proceedings.
Would you say that he is just generally reliable?
Yes.
All right. Tell me about you. Would you consider yourself a responsible member of the community?
Yes.
What do you do for a living?
I'm in the gasoline and diesel fuel business. We operate Collins Oil Company.
Is that a family business, I assume?
Yes, it is.
How long has that business been in place?
60 years.
60 years.
60 years. My mother and father started it, yes.
Have you always worked for Collins Oil Company or owned Collins Oil Company?
Yes.
All right. And when did you begin working there?
Ooh, oh Lord. I started working there when I was a child, and then I started working there after college, probably in the 81, 82.
Would you consider yourself to be active in the community?
Yes.
All right. As far as that goes, are you a member of clubs and organizations?
Not anymore. I used to be in Rotary.
Okay.
And I've been in several clubs, and I've been active at church and on church boards and chamber board and different things of those natures.
Do you have strong family ties in the community?
Yes.
Okay. Are you financially stable?
Yes.
Do you own your home?
Yes.
Okay. Do you take care of your responsibilities?
Yes.
Would you say that Mr. Liner does as well?
Yes.
Do you feel that if he were granted a reasonable bond that he would appear as instructed by courts?
Yes, I think he would.
Are you comfortable with Mr. Liner being in the community?
I would be personally, yes.
Those are my questions.
Just a few, Judge. Mr. Collins, you testified that you knew the defendant to be in a good or stable financial condition. Is that correct?
Yes.
Did the defendant ever tell you that he was fired from his job?
No.
Okay. Would you consider someone who has recently been fired to be in good financial condition, just in generally?
I would in his case. And generally, I don't know about
Okay.
that, but in his case, he's in good financial positions, I think.
Okay. As we all stand here today, is he still in good financial condition to your knowledge?
Yes.
Okay. Are you aware of any other litigation affecting his finances?
Not that I'm aware of.
You're not aware?
I'm not aware, no. I'm
Okay.
not aware
You're
of
not
any
aware
other
of
litigation,
Any
no.
other litigation involving the defendant?
No.
Okay. And since the defendant has been in jail, incarcerated here in the Bradley County Jail, have you been in contact with him?
Yes, I have spoke to him.
Okay. Is that on the phone or? in
Over the
person?
phone, yes. I can just speak to him over the phone, yes.
Okay. One moment, Judge. Judge, I don't have any additional questions for Mr. Collins.
Anything else?
Mr. Collins, I'm not
Yes.
sure you understood General Zepeda's
Yes.
question. Are you aware of a court order that freezes Mr. Liner's assets?
Oh, yes, I am aware of that, yes.
Okay.
I did not understand that, but I am aware of the court order that Judge Sharp, yes.
Okay, so there's a court order that essentially says that before Mr. Liner is allowed to access any of his funds that he earned throughout his life or inherited from his parents, he has to make application to another circuit judge for the release of those funds. Is that
I'm
correct?
aware of that, yes.
Okay, and I attached those to my motion and memorandum for bond.
Okay.
You've seen those, haven't you?
Yes.
All right. Have you seen the effect of those?
Yeah, what
Have
now?
you seen the effect of those? Have you helped Mr. Liner?
Oh, I have seen the effect of those. Yes, I'm his personal representative,
Okay.
power of attorney.
Yes.
And yeah, that is delayed my responsibility of paying his bills and doing some things.
All right. Have you, in fact, gone out of pocket to service some of Mr. Liner's bills because
Yes.
of that order?
Yes, I have.
Those are my questions. Thank you, sir.
Okay.
Just one brief redirect, Judge. Mr. Collins, if the defendant no longer has a job and cannot access money that he earned previously in life until making application to the court,
Yes.
would you consider that to be in good financial condition, no job and no access to your past money?
I don't really know if that would be or not. I think the court will give him access to his money, some of it at the judge's discretion.
Okay, but if he were released today, he goes out on the street, is it correct that he doesn't have a job and he does not have access to his past money unless another court tells him he can?
As far as I understand, yes.
Okay, those are all my questions, Judge.
That's fair.
Thank you, sir.
Okay, thank you.
Your Honor, as far as witnesses goes, that's the defense. I have some exhibits that I would like to pass up. The state has indicated that they're not going to lodge an objection to these certified documents from the clerk's office. Some of them are rule documents, if I may, Your Honor. But as you saw in the memorandum in support of bond that went along with my motion for bond, I listed for the past 10 years any first-degree homicide cases that came through this court or the Circuit Court of Bradley County, and I did a statistical analysis for that. These certified records back up the synopsis that I put in my motion. I'll tell Your Honor, we studied on it very hard, we're diligent in that, and made sure that the motion was correct. But I encourage Your Honor, if you have questions or want to look at it, that there's the record certified by the clerk. Also, I have, and I would like that to be marked the next exhibit if it please the court.
Yes. Exhibit 5.
Also, I have a letter from Dr. Mark Williams from the Church of God International offices that attests to the reliability of the defendant Liner. I have exchanged that with the DA's office, and I know from my prior conversations with them that they have some objection to that letter or maybe its content. I believe it to be reliable hearsay for the purpose of bond only, not the prelim. And I will tell Your Honor that Mr. Williams, Dr. Williams from the church, was not able to be here today. He's out of town today, so he wrote this letter at my request.
Judge, the state's position would be that, one, the content of the letter is not relevant to any of the factors laid out in 4011-118. It describes counseling following the death of his parents and attendance at church. The state has informed the defense that we would be willing to stipulate that the defendant is a member of that church or attends that church, but the content of the letter is not relevant. And going beyond that, it's not reliable hearsay, because if you look at the letter, the writer does not state his, he does not state those things as facts or as a conclusion. He says, it is my recollection that. So the state would submit that this is not reliable hearsay, as Rule 5.1 has deemed written reports of expert witnesses. This is a letter written by a layperson that does not even state facts. It states recollection of facts, and the state has no ability to cross that person.
Your Honor, if it pleases the court, I want to make sure the record's clear. Nothing in the letter says that he's a member of the church or currently attends that church. My client's currently incarcerated. Dr. Williams is no longer a pastor in the sense that he has his own congregation. He is an administrator in the Church of God International offices. He opined in his letter as to Mr. Liner's reliability. The state wants to make a crutch for their argument that says, based on my recollection, I believe Mr. Liner to be a reliable person. That's the only way you can opine as to whether someone's reliable or not, based on your recollection. That's how memories, that's where memories come from, is what you recall. So to say that it's not even stating a fact is, you know, disingenuous, essentially, because what you recall is what you recollect. Your memory and your opinion is derived from those very things. I do believe on the self-authenticating letterhead from the International Officers of the Church of God, this could be considered reliable hearsay for the factor.
All right, well, I'm going to admit it as an exhibit, and then I think the arguments from the state go to what weight it's given. It is a letter that states he went to counseling appointments and didn't miss an appointment, it looks like. So I'll take it just for that purpose, that he went to counseling appointments without missing. So back in 2016.
Thank you, Your Honor.
Anything else?
No, that's the proof.
Okay. All right, so we have a lot of things to go over, I think, today. We're doing two things at once. We're doing a preliminary hearing, a bond hearing, and I'll have questions for both sides, I think, as we go through the arguments. I think it probably makes the most sense to start at arguments on the probable cause side of the preliminary hearing. The burden of proof is on the state, and so I'll let the state argue why I'm sure they think probable cause has been met.
Yes, Judge, thank you. As for first-degree murder, and just going through the elements, the killing of another, Exhibit 4, the autopsy report establishes, as does the testimony of the Detective Nation on the case, that Karen Liner died of multiple gunshot wounds and that the manner of death was homicide. As for it being a premeditated and intentional act, I would refer the court to Exhibits 1B, Exhibits 2 and 3. The defendant drove a different vehicle to the scene before going to Miss Liner's residence in a neighborhood in the middle of the day. He went to Jay Collins' house, where he switched cars to a car that he does not typically drive, to a car that he didn't even buy for himself. He bought as a car for his son to use when the son's car was damaged. So he switched cars to a car he does not normally use. And in that car, he brought with him multiple guns that Jay Collins testified the defendant told him he needed to get rid of. multiple guns that were turned over to law enforcement, and more specifically, a .40 caliber gun that matched a .40 caliber casing that was recovered from that different vehicle, the Lincoln, that the defendant drove to Karen Liner's house. Karen was shot from behind. You can see that on Exhibit 2, the vivid security video from the neighbor's house. She is running away from the defendant. She's fleeing when he shoots her from behind. But he does not stop there. He gets in his car, he turns on his car, moments go by. Detective Nation described it as an extended pause, referring back to Exhibit 1B on the 911 recording. Between the second to last shot and the final shot, you can hear the dispatcher ask multiple times if she's still there. You can hear the dispatcher frantically typing. A significant portion of time goes by, and then we all saw today on video the defendant partially exit his car and shoot a kill shot into the back of Karen Liner as she lays on the driveway, defenseless. There is significant case law that establishes that multiple shots are evidence of premeditation. Using a weapon on a fleeing person is a sign of premeditation. Driving a different vehicle, planning that out in advance, is a sign of premeditation. And it doesn't stop there, because another significant sign that is repeatedly cited by both the Court of Criminal Appeals and the Tennessee Supreme Court is a calm demeanor after the crime. We saw the defendant slowly back out of the driveway in the Lincoln that he specifically chose. An inference that can be made is so Karen wouldn't recognize when he drove up to her new house. He slowly backs out and slowly drives away. He's not in a rush. He's not frantic. He's calm. We also heard just how calm he was from Detective Fox and Detective Nation. We heard from Jay Collins himself that as the defendant drove up to the Bluff residence in the Lincoln with the multiple firearms and the shell casing in the car, he was calm. There was nothing off about his behavior. The state would submit that there has been ample evidence of premeditation and an intentional act by the defendant. As far as felony murder, the state would submit that there has been proof today sufficient to find probable cause that the murder of Karen Liner was committed in the perpetration of a burglary. We saw the defendant go into the garage that is attached to her home on Exhibit 2. We could see, and Detective Nation noted in his testimony, that you can see the garage door closing, and then the defendant scurries and ducks under the door so he can get into the garage, even though Karen is actively closing it. And we all heard on Exhibit 1B, the 911 recording, her telling him to get out and that he couldn't be there, and screaming and fighting for her life. So the state would submit that there has been ample proof that Ms. Liner did not consent to that man coming into her garage. And with felony murder being established by probable cause, the defendant would be properly bound over to criminal court as charged, based on the proof that the court has heard today.
Right, Mr. Rogers.
We limited to probable cause argument?
Just the probable cause, then we're gonna split up. I have one question and about bond and then maybe possibly more. So just probable cause for now.
Your Honor, for the state to argue that there is clear evidence of probable cause for first-degree premeditated homicide or felony murder, you would have to believe that Mr. Liner planned and premeditated to kill his wife or his ex-wife in broad daylight on a Ring camera. If that's premeditated murder, that's the worst premeditation I've ever even heard of. It doesn't make sense to call this premeditated murder. I acknowledge that Your Honor, based on the proof that you've seen here today, can say that yes, there is probable cause to believe that Charlton Liner committed an offense on this particular day, and it's maybe probable cause for some version of homicide. But to say it's some sort of planned attack and event and premeditated is just an assumption, Your Honor. They did an investigation. It's still ongoing. I'll give them that. But you have to judge this case on the proof that's before Your Honor. We don't have phone records, text messages, emails, phone call logs, or anything that the state's decided to prove about whether these parties, the victim and the defendant, were talking or conversing, whether it was expected, whether Mr. Liner was simply driving by and saw his wife in the driveway or garage and decided to go talk to her. A premeditated murder requires more, Your Honor, and because of that, I think the case is weak, at least the case that's been presented to you today. I'll be glad to talk about bond, but if you want the state to argue about that, I'll reserve.
Do you have any arguments toward the felony murder charge?
Sure, yes. I think that's a stretch as well, Your Honor. They say he entered the home. Yes, you can see that he entered the home, but they have to prove that he entered the home with the intent to commit a theft or some type of felony therein. Same argument goes to the premeditation. What was he going to do? I mean, you heard an officer say that he didn't know. He saw him bend down and pick something up and take it. He assumes it might be this or that or a pair of glasses. There's obviously an unfortunate and tragic event here, but we have to look at it through the eyes of the law, and there's no proof to say that that was necessarily a felony murder. It has to be a burglary, and we don't have anything. There's missing elements.
Judge, if I could respond just briefly to that very last point.
Okay.
The state would just note that the defense left out the theory of burglary based on entering without consent with the intent to commit an assault or actually committing assault. And the state's final statement on the matter would be that killing someone, gunning them down in their driveway would constitute an assault as laid out by the legislature of Tennessee.
That's just it. They'd have to prove that he intended to do that. That was the premeditation. It goes hand in hand with the charge.
All right. Well, I think it's always important to note anytime we have a probable cause hearing in any matter, whatever the matter may be, although it probably felt like a trial for the witnesses who have testified today, it is not a trial today. It's what's called a probable cause preliminary hearing, which means my burden of proof is down here. It's probable cause. Did it probably happen the way the state says it did? Obviously today Mr. Liner's not being convicted of anything, of any crime today, because that takes beyond a reasonable burden, which is way up here. My burden today is just probable cause. So I'm judging this case based on probable cause, which is a very low determination. I'll go through the proof. I think the state laid out much of the proof in their arguments. Defense responded to much of it in theirs. But the law on a first-degree murder, if I have it up here somewhere, there it is. First-degree murder is a premeditated and intentional killing of another, and that's count 1 of the arrest warrant alleges that. Premeditation is defined as an act done after the exercise of reflection and judgment. Premeditation means that the intent to kill must have been formed prior to the act itself. It is not necessary that the purpose to kill pre-exists in the mind of the accused for any definitive period of time. The mental state of the accused at the time the accused allegedly decided to kill must be carefully considered in order to determine whether the accused was sufficiently free from excitement and passion as to be capable of premeditation. So premeditation does take exercise of reflection and judgment, although I'm aware of no case law that says that means it has to be a perfectly planned crime where someone can get away with it, basically, for it to be premeditation. It's the judgment, the thinking, what I'm about to do is kill someone and end their life. I do think there is more than enough probable cause to send count 1 of the arrest warrant up to the grand jury. As I look through the evidence, I've taken kind of notes of what happened the day in question for probable cause purposes. Mr. Liner got in a car that he does not usually get in, a car that he would not, most people, unless they really knew him, wouldn't even know probably from the sound of his cousin, from Jay Collins' testimony, that he drives that car. He doesn't regularly drive it. And he got in that car, exchanged his normal car for the Lincoln. He arrived at Miss Liner's home around 8:45 in the morning. you can, there's the 911 call we've listened to where Miss Liner is clearly telling him not to come in. The garage door is going down in the video that the court watched in another exhibit, and you can see as the garage door is descending that Mr. Liner goes up to it, and it then goes up probably from a motion activation on the door to not let it keep going. So he opens the door, goes in. There's a gunshot almost immediately upon him entering. Miss Liner is in the garage, her own garage. All the testimony is that this was her home, that they are no longer a couple, that this home is hers and it's not a joint home. And so this is a home that he did not have permission to be in. So he does go into that home. There's one gunshot, several seconds, and then 2, 3, 4 gunshots after that. There is, throughout that whole time, after an initial, which can be made out, Miss Liner saying, "Craig, please stop." After that, there's an audible screaming, which could only be said that Miss Liner is begging for her life at that point in time, after the first shot. And then 3 more gunshots rain out. Miss Liner is seen falling out of the garage onto the pavement of her driveway. The video shows Mr. Liner getting into his vehicle. There's a sound as if he is starting the vehicle after that point. Several seconds transpire after the starting of the vehicle, and I have at least 10 seconds on the video that I put in my notes, and then a final shot from the videos that were before me. Clearly, Miss Liner is deceased with a gunshot wound to her head. Just from the video, there is a pool of blood at her head, and the autopsy confirms that she was shot 3 times. The first shot, we don't know. I don't know from the testimony today which shot was which, but definitely a through gunshot wound to the head, another gunshot wound to her left shoulder, and then one through her chest. After finishing off Miss Liner, Mr. Liner gets in his vehicle and drives back to his cousin's house. His cousin testifies that he just happened to be there. It is interesting because Mr. Collins testified that he had gone to work that morning and then just happened to go back to his house. And so from that, it can be assumed perhaps that Mr. Liner didn't even know that his cousin would be there when he was getting rid of the vehicle that he used to commit this crime for probable cause purposes. And he ditches the car. His cousin does happen to be there, and he confesses to him. The cousin stated that Mr. Collins said that he got out. He said, I need to get rid of this. He gave him 2 to 3 guns. He says, "It's over. I finished it," the defendant said, and the cousin took it that he had killed his ex-wife, Karen Liner. The cousin, Mr. Collins, says he wasn't sure if it had happened, but he believed it enough that he took out what he believed to be the murder weapon with a glove and put it outside of his house because he didn't want a murder weapon in his house, is what he said. And then the defendant gets in his normal car and drives back to his home, which is where police come to him. Lieutenant Fox testified that when they arrived, there was very little emotion, if any, from the defendant. And again, that goes to back to the premeditation. That part of premeditation is it's free from excitement and passion. Obviously, this is after the fact, but it shows a reflection. It shows that this was not just a heat of the moment for probable cause purposes. And again, his demeanor was corroborated by Detective Nation, who interviewed Mr. Liner, and said that he was just no motion. He acted normal, and he asked no questions when he was told that his ex-wife had been murdered, had been shot, and he was just normal. So I do think that when all of those come together, I think it is a very strong case for first-degree murder with premeditation for probable cause purposes. Again, my burden is down here. It is not beyond a reasonable doubt. And so I am sending that matter to the grand jury, where we'll likely go from grand jury and then to criminal court, where a trial and a jury can decide beyond a reasonable doubt if that exists. As to count 2, the felony murder, Again, my burden is probable cause. Felony murder is the killing of another committed in the perpetration of or attempt to perpetrate any first-degree murder, arson, robbery, burglary, theft, kidnapping, and a list of other crimes. The state is arguing that this was a killing of another committed in the perpetration of or attempt to perpetrate a burglary. And again, I think for probable cause sake, that this has been met. No side is offering case law today on delving into maybe more about the definition of that. But burglary, if you look at the TCA code, a person commits a burglary who, without the effective consent of the property owner, enters a building other than a habitation is a regular burglary. A habitation is an aggravated burglary, and so without their permission or consent, I think there is copious proof from before me, very strong proof that Ms. Liner did not want Mr. Liner in that her home. She, as I've already gone over, the garage door is going down. She's on the phone to 911 when he enters, makes his way in, and the assault begins. The shooting begins when she is still in her home in the garage. And so I do think that that would be, and obviously the assault leads to her death, as I've already stated on the first count. So that would be a killing of another committed in the perpetration of or attempt to perpetrate a burglary. And so I do find that there is probable cause today to send both matters to the grand jury from my court. Which then leads us into the bond portion of this before I sign any of the paperwork to lose jurisdiction. My first question is obviously, this case has now been going on since January 27th. Mr. Liner was arraigned January 28th. I did hold him no bond that day till a bond hearing could be held. We've gone through this before, but defense requested that we set it to the 10th of February. Obviously the state said they would have been ready to go later that week on Thursday or Friday, and then on Monday, February 3rd, so he was held no bond until the 10th. On the 10th, there was a recusal motion. The state, or not the state, the court overruled it, and then it was set to today at defense request to be ready for this full hearing. So Mr. Liner has been held no bond the entire time. The court's gone over its reasoning for that. Under our laws and our Constitution, all prisoners shall be bailable by sufficient sureties unless, and this is reading Tennessee Constitution Article 1, Section 15, unless for capital offenses when the proof is evident or the presumption is great. And my position on that, since the arraignment, is I won't need to hear proof before I feel comfortable setting a bond on a first-degree murder allegation. I've now heard proof. And so my question to the state, obviously many people might assume, hey, any first-degree murder is a capital offense, but that is not the case. Our legislature has decided, and I think following some United States Supreme Court cases in the 60s and 70s, that not just any first-degree murder, although a horrific crime, can be punished by death, and a capital offense has to be a case. Is a capital crime is defined by Black's Law Dictionary, which has been adopted by our courts as a crime in which the death penalty may but need not necessarily be imposed. So my question to the state is it the state's position this is a capital offense? And if so, what are their arguments in favor of that position?
Yes, Judge, the state's position is that looking at the aggravating circumstances enumerated in TCA 3913-204, that seventh factor would be applicable based on the facts of this matter. That the offense was knowingly committed by the defendant while the defendant had a substantial role in committing or attempting to commit, and several different qualifying felonies are listed. The one that would be applicable to this case is burglary. So the state would submit that the proof that has been heard on probable cause to establish felony murder would also establish that seventh factor. And this is something that has been addressed by the courts. The Supreme Court of Tennessee in State v. Banks, 271, Southwest 3rd 90, specifically addresses this issue. On page 152, using the page numbers listed in the case, they specifically address when felony murder can be an aggravating circumstance qualifying an individual for the death penalty under the 8th Amendment, and they state that with the new changes to the law that occurred in 1992, that a conviction for felony murder is sufficient to establish that factor. So the state's position would be, so long as the state can prove that the defendant committed felony murder, and the state's comment on that would be that there has been ample proof, heard just today, a mere 25 days from the murder, that would also provide sufficient proof of that aggravating circumstance 7.
All right, any response from defense?
Yes, Your Honor. Based on that initial inquiry by the court, I think it's important and incumbent upon the defense to point out just what Your Honor did. I agree with Your Honor's assessment about just because it could potentially be a capital defense doesn't mean you can withhold bail or bond. Here today, I acknowledge Your Honor's findings at the preliminary hearing that there's probable cause to bind over the cases. Probable cause does not necessarily mean strong. Probable cause does not necessarily mean clear. And probable cause doesn't necessarily mean that the defendant loses the presumption of innocence. Your Honor, our courts have been clear to us that the traditional right to freedom before conviction prevents the unhampered preparation of a defense and serves to prevent the infliction of punishment prior to conviction. Your Honor knows this. I quoted it in the motion for bond. Your Honor's findings, while strong in and of themselves on a basis from a misdemeanor to one of the 8 felonies that we sometimes look at, doesn't encompass the withholding of bond factors. Your Honor has to find that the presumption is great, that goes away and that the defendant loses that here. That has not been upheld by the state. I want to point out to you what I pointed out in the exhibits and in the motion, that in the past 10 years, there have been only 5 cases that have come through this court where bond has been denied. Of the other first-degree homicide cases, the bonds range from $50,000 to $1 million. $1 million being the highest, $500,000 being the next, or $515,000 being the next highest, then $500,000, $150,000, $50,000, and so on. If you look at those records that I quoted in my memorandum, we acknowledge that certain cases, certain defendants were held without bond. In those cases, we researched those. Docket number 153482 was regarded a defendant that had numerous felony warrants from other jurisdictions at the time of his arrest in criminal conduct. The next one was the defendant was charged with the murder of 2 people, a mother, a child, and confessed. The other one was the defendant was initially denied bail, but later granted bail in the amount of $500,000. So maybe you can even take that one out of those in favor of the state for holding without bond. The next one was a defendant that was charged with first-degree murder times 2, conspiracy to commit first-degree murder, tampering with evidence, and abuse of a corpse. The next one that was denied bond was the co-defendant to the double homicide and the abuse of a corpse person. And the last one was someone that was held without bond that was accused of murder in front of live witnesses while under the influence and after a promise to do harm to that person. In this particular case, you have none of those, Your Honor. You have Mr. Charlton Craig Liner, and this may be off-putting to some people, but if this would have happened between 2 exes down on Wildwood in a different part of town, between people that didn't have resources, between people that were unknown, it would be a mere blurb on the news. Your Honor would have set a bond as a matter of course, my prediction is. The person would have been appointed an attorney from the public defender's office, paid for by the taxpayers of the state of Tennessee, and the case would have been bound over at some point before now. The defendant has been, not by this court, he's been judicially impoverished, or at least a hold put on any money that he earned or inherited from his family. He's been held without bond. He's made arrangements for his own defense to be here, and because of his record, we are here with a courtroom full of press. Press is pressured. Your Honor looked at me just a few days or weeks ago at my request for recusal, which Your Honor acknowledged was brought in good faith, and said, Mr. Rogers, I hear you, but I can do my job. I'm going to overrule you. You're a friend and a colleague, and I disagree with you. I can set all those things aside and move forward. And the allegation was not that Your Honor was somehow not suitable for the job. It was that your connections gave some appearance of impropriety. Your Honor looked at us and looked at this community and said that you could do your job. I think you can. I think Your Honor can consider the factors, can consider pretrial denial of bail as punishment, just as our Constitution and our forefathers and our legislatures have set forth. It's interesting to me that when you look at the code regarding setting of bond, it specifically sets out that if a judge is unavailable to set bond, even in a homicide case, a clerk can or shall set bond for somebody if the person's held a mere 3 hours. And it puts a cap on that. A clerk can set a bond on a homicide case up to $100,000. That's a ceiling, not a floor. Our courts, our law, our Constitution protects the presumption of innocence to a degree that ensures bail. The law also directs Your Honor in the courts to look at the least restrictive means available to ensure that the defendant shows up to court, not to punish, not to satisfy the pressures from society or victims or witnesses or family members or people that have opinions. Your Honor has been tasked with the job to be blind to all of those things. Now, we can see the press and the pressure and the crowd here in the courtroom today, but Your Honor told us you could do your job. I believe that Your Honor will, and set Mr. Liner a reasonable bond, looking first to recognizance, then to see if restrictions are necessary, and thirdly, to set an amount of money if the court thinks it's necessary to assure that he shows up to court. I suggest, Your Honor, one of those bond amounts within the median or middle range of any bond that was set on a homicide case in the last 10 years is sufficient to ensure that Mr. Liner, even that shows up to court, even the state's witnesses today couldn't tell you that they didn't think he was reliable or would not show up to court. That's the standard. He needs to get here, he needs to show up, and I think it's right and just under the law.
Judge, if I could respond, because it was my understanding that we were to limit our argument to whether
Well,
the death penalty applied.
One moment. Mr. Rogers, you argue well, but my question right now, because under our laws, under the Constitution and also the Tennessee Code, TCA 4011-102, everyone's entitled to bond except if it is a capital offense. I will just say I've gone through the evidence of this. I'm, again, not ruling yet on whether it's a capital offense. I want to hear both sides. I've heard the state side. I want to hear your side. I think there's been probable cause met, but for someone to be held on a capital offense without bond, the proof is evident and the presumption great. I'll just say before I throw it back to you, Mr. Rogers, there is state ex-rel Jefferson versus State 222 Tennessee 413-415 from 1969. It states, in the General Sessions Court hearing, the state was correctly required to carry the burden of proof and offer evidence to sustain the right of the state to retain the petitioner in custody, since this hearing on the issue of bail was held prior to any indictment. And so the standard in that was that it's the state's burden to show that, and I do think that they've shown that proof is evident and the presumption is great today. So my question before I even think about setting a bond is it your position this is not meeting one of the aggravating factors of a first-degree murder for a capital offense?
Yes, Your Honor. I agree with your logic as well, that it's the state's burden. I heard Your Honor say that you believe the proof was evident of the crime itself, but is Your Honor finding that proof is evident and that it's clear and that it's a capital offense? That's the question.
Well, the state's position is it is meets number 7. It was a knowingly committed murder by the defendant while the defendant had a substantial role in committing or attempting to commit a burglary.
And that burglary is the fact that it happened inside the curtilage of a home or inside the garage door. Is that what your Honor's finding?
Clearly the state's position. That's what I found for probable cause purposes.
And was there intent when he crossed the threshold? How do we know what that is? There's been no proof before, Your Honor. Your Honor's has found that he went and changed cars to perpetrate the crime, and I hear, Your Honor, how maybe that could be a logical conclusion, but we haven't heard any proof of that. Maybe he went, as Mr. Collins told us, to go get the car that he talked about selling, because he's not allowed to have 2 cars at his apartment where he's moving to. Maybe it wasn't part of some grand scam, plea or plan or premeditation. Maybe it was something else, and if there's a maybe it was something else, the proof can't be cleared and the presumption can't be great. We don't know those things. We can only assume those things. So I think bond is appropriate. Be glad to answer any other questions.
Does the state have any response?
Yes, Judge, the state's response would be that we have proof, both in the form of a video and a 911 call, that that man entered Karen Liner's garage without permission, without a gun. And I think that an inference can very reasonably be made that if you go to your ex-wife's house that you are not supposed to be at, that she tells you to leave, she tries to shut the garage door, and you scurry under with a firearm and shoot her 4 times, that is evidence that at a minimum an assault has took place. I would also submit that you can make an inference you don't go into your ex-wife's garage with a firearm unless you have intent to do her harm. As far as the other factors going through bond specifically, I would like to reply to Exhibit 5, the defense exhibit of other bail amounts in other cases. I'm not going to object to a public record. However, the state's position is that other individuals' bond amounts are not relevant to this defendant's bond determination. And that has actually been very specifically addressed by the Court of Criminal Appeals in an order that is actually originating from a case in this district, where in Monroe County, Judge Freiberg held a bond hearing because one co-defendant had a much higher bond. That was reversed by the Court of Criminal Appeals. If you go to the bottom of page 6, however, the statutory bail factors in section 4011-118B do not expressly include consideration of whether similarly situated defendants should be treated alike in terms of bail or conditions of release. Nor could these factors allow for this consideration implicitly, as each of the section 118B factors is highly individualized. Indeed, in this highly individualized determination, bail is required to be set as low as the court determines is necessary to reasonably ensure the goals of pretrial release. As such, we are aware of no authority that would require or even allow an appropriate bail to be increased because the bail for another individual is set in a greater amount. So the Court of Criminal Appeals position is crystal clear that there is zero relevance in somebody else's bond. So I think that is all we need to know about Exhibit 5. As far as the remaining bond factors, specifically number 6 that is enumerated in 118, the nature of the offense and the apparent probability of conviction and the likely sentence. The nature of the offense is first-degree murder and felony murder. I don't think we need to address the proof any further. The defendant is facing the death penalty. He could face the death penalty. So the state's position would be that the nature of the offense could not be more serious, nor could it be more grave, and the stakes for the defendant could not be higher. As far as the likelihood of the conviction, the state would submit that the likelihood is certain. We have seen just today video of the shooting, a 911 call that recorded the audio of the shooting. That video clearly shows the defendant's person, the defendant's car. We have the murder weapon, we have a casing, and we're only 25 days in Detective Nation testified that many items were sent to TBI for analysis, so there could be potentially even more proof tying the defendant to this crime in addition to the ample proof that we have heard today. Lastly, bail is supposed to be sufficient to ensure the defendant's return to court, but also, as the defense continues to fail to address, the safety of the community. That is a huge factor. That is just as important as whether the defendant returns to court. And we heard testimony from Ms. Hopper that she and her family have grave concerns for their safety should the defendant be released, specifically regarding their custody of their granddaughter, the defendant's daughter. And we have heard extensive proof. And the last thing that the state would say is that just as Detective Nation testified, it is the state's position that any and every homicide is a major one. Regardless of whether the news writes an article or films something in court, the state takes every homicide extremely seriously, regardless of who committed it, where it was committed, and the financial conditions of the people involved. In any situation where somebody guns down their ex-wife at 9 a.m. in the middle of a neighborhood in Bradley County, the state is absolutely going to take it very seriously and treat it as a major case. And that would be the state's position for withholding bond.
All right, I'm about to rule. Do you have any last word that you would
Your
like
Honor,
to
I have my arguments.
Okay. All right. I'm going to quote another case. This is talking about a trial court, not a sessions court, on the capital offense inquiry. That court, this is Shaw versus State, 164 Tennessee 192 from, I don't have the 1932. It's an old case, but it does go over what is meant by our Constitution, by what a capital offense is, and when it says the presumption great, proof is evident. It says the General Assembly has not deemed it necessary to prescribe formal rules to be followed in determining the right of a defendant, in this case obviously a trial court, so an indicted defendant, to be released from custody on bail, nor do we think the reasonable discretion of the judges should be circumscribed by arbitrary rule of judicial origin. The reported opinions of this court disclose no previous controversy with respect to such procedure. The right to bail in a proper case, being a constitutional right, should be and is guarded scrupulously by the trial judges of the state. In a capital case, the existence of evident proof or great presumption of guilt is not often capable of ascertainment with mathematical certainty on a preliminary hearing for bail, and the trial courts are not likely to be influenced in their judgments upon the weight of evidence by technical rules respecting burden of proof. But the order granting or denying bail should be made advisedly, and we think it is a reasonable requirement that the applicant offer the witnesses upon whose testimony the grand jury found the indictment, or, as in the practice followed by some judges of the state, the judge may, on his own motion, call the witnesses endorsed on the indictment and require that they be examined by the Attorney General for the enlightenment of the court. Finally, we think the course of the inquiry may be left safely to the discretion of the trial courts. Now, clearly this is about the next level, but I think that it goes over some good points for me today as a sessions judge. And again, I'm the lowest judge in the judicial organization of our state. Things come through me and go on to trial courts, appellate courts, the Supreme Court. But I think that the key here is we think the course of the inquiry may be left safely to the discretion of the court. I have heard for the state multiple witnesses that will no doubt be before grand jury and called at trial. I think the proof is extremely strong in this case. And I do think when I'm looking at TCA 3913-204, that seventh factor where a first degree murder can become a capital offense, and again, to be held no bond, it doesn't need to have the death penalty imposed. A capital crime is defined as one in or for which the death penalty may, but need not necessarily be imposed, from State versus Wiggins, citing Black's Law Dictionary. I do think that this is a capital offense today after hearing proof based on the burglary factor in this crime. And so I am going to send this case to the grand jury with no bond. Obviously, for Mr. Liner, my decision can be immediately appealed to the next level judge, but I do think that this is a capital offense. I do think that it is extremely strong proof, and I do not think that a bond is entitled to Mr. Liner under our Constitution or under our statutes. So I will send this matter from my court now to the grand jury. Mr. Liner's next court date, unless it goes there for a bond hearing, a bond appeal, anything of that nature, but it should be through the grand jury, and in that court, the report back date would be April 28th at 8:30 in the morning, not in my court, but across the hall. And so I will send that on its way as a no bond.
Thank you, Your Honor.
Thank you.
Thank you, Judge.